Good morning, everyone. Welcome to the Thursday, June 11th, 2026 agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission. I'll take the role of the other commissioners who are present for today's hearing. Commissioner Partridge.
Here.
Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
I'm here.
A quorum is present. We'll take our any votes today by orally because we're all in person. Mr. Manning, to you and your staff who helped prepare us for this agenda item, first I'd like to thank you and the administrative law judge for a well done record that's before us. So with that, will you please introduce the item?
Thank you, and good morning, Chair Sieben and Commissioners. Today's agenda item is oral arguments for docket number E002/GR24320 in the matter of the application of Northern States Power Company, doing business as Xcel Energy, for authority to increase rates for electric service in the state of Minnesota. The commissions before the decision, questions before the commission today are: should the commission adopt the recommendations in the ALJ report? If not, what level of revenue is appropriate for the company during the next test year? And should that revenue be collected from customers? There are a couple of items I would like to bring to the Commission's attention. First, Xcel filed a response to the motions of the Department and the OAG to take notice of several documents. Second, the several parties filed modified and recommended decision options, with the Department of Commerce filing on June 5th, the Office of the Attorney General on June 8th, Xcel and the joint interveners on the 9th, and Xcel Large Industrials on the 10th. Parties have been notified of a schedule for opening statements, and staff is available for questions. Thank you.
Thank you, Mr. Manning. And just a little bit more about the schedule for today. First, we'll hear arguments from parties, from formal interveners, according to the schedule that was filed by Mr. Manning. Then we'll likely take a lunch break for approximately an hour. And before we take the lunch break, we'll also likely vote on the motion to accept the filings that are in the record now. And then following opening statements, we'll move through the volume sequentially with commissioner questions to parties. And this is a little bit of a deviation from what we've done previously with rate cases, but I'm going to ask commissioners to pre-file tomorrow decision options that may deviate from the ALJ report that impact the overall financials of the rate case, and then ask the company to file an updated schedule on Monday. And we can discuss this more with commissioners as we move throughout our questions this afternoon. But the idea is that it will give parties and the commissioners a better sense of where things are at prior to deliberations on Thursday. So, and commissioners, if you have, again, we can talk about this as we move throughout questions today and throughout the volumes. But again, what I'm thinking is that if a commissioner wants to file something that, again, deviates from the ALJ report or wants to help demonstrate to parties and other commissioners where they're at, if they could do that before the close of business tomorrow, so that then Xcel can file an updated schedule on Monday. I think that would be helpful for transparency for everyone. So with that, we'll move to opening statements. And I'm not sure about everybody who's speaking on behalf of the parties here, so when you introduce yourself, please also indicate if there are other people online or with you that are available for questions. So we'll begin this morning with Xcel, and according to the statement or the oral argument schedule that was released, you'll have 30 minutes. So, Mr. Dobson, good morning. Please state your name for the record.
Thank you, Madam Chair. Ian Dobson with Xcel Energy. I'll say at the outset, I will not take all of the 30 minutes, but thank you. I think first, I want to thank the Commission for the time and attention paid to this matter, and to your staff for their efforts in compiling and summarizing what is obviously a very extensive record. This is a crucial case for the company and for our ability to continue to enhance the service that we provide to our customers and ensure that it is increasingly reliable, clean, and valued. As the Commission knows, we are in the midst of a significant and exciting transition to decarbonize our electric system and at the same time further improve the service we provide to our customers. During just the course of this 2-year MYRP, we're deploying well over $1 billion for new clean energy resources, including the repowering of 2 large wind farms, the completion of Sherco Solar 2 and 3, and the upcoming completion of the Sherco batteries. In addition, over these 2 years, we're investing more than $500 million into our carbon-free nuclear facilities as we plan to operate those facilities for decades into the future. We're also making significant investments throughout our distribution system to renew these assets, improve reliability for our customers, and reduce the frequency and duration of service outages. And we've begun to address the emerging threat of wildfires to our service territory by setting up a specialized wildfire team who oversees a series of investments and programs that provide layered protections against potential ignitions. All the while, we're experiencing significant upward cost pressures for our labor, materials, and other inputs of providing service. The rate increase that we have proposed here is needed for us to recover these increasing costs and raise the capital necessary to continue making the significant investments needed to serve our customers. Having said that, I want to address the concerns expressed by some parties in this proceeding about the affordability of our service. While the Commission's rate decisions need to be based on the necessary costs of providing service, we recognize that the Commission is always cognizant of the impact that our rate increases have on our customers, and that the Commission is dedicated to addressing the affordability challenges that some of our customers face, a priority that we wholeheartedly share. And while we agree with that priority, we think that the other parties in this proceeding have incorrectly concluded that the cost of our service is generally unaffordable, presumably for all or a significant portion of our customers, and that either denying a rate case altogether or granting a rate increase that is lower than our cost of service is the appropriate remedy for some customers' very real affordability challenges. Both of these premises are flawed. First, despite several parties' arguments to the contrary, the cost that our customers pay for their electric service remains well below the national average. The Department of Commerce, the Attorney General, and others have suggested, however, that our service has become generally unaffordable because we have received more frequent Commission-approved increases to our base rates over the past decade than other utilities that are regulated by the Commission. But it is customer bills, not the frequency of our base rate increases, that determine affordability. A complete analysis of our customers' bills and the drivers of those bill changes shows that the cost of electric service for our customers has actually grown far slower than it has for other utilities nationally, regionally, and in Minnesota over the 10 years preceding this case. And this is because while our base rates have increased, our sales have decreased substantially, even as our customer base has grown, meaning our customers are using substantially less energy on a per customer basis than they were 10 years ago. Specifically, during the 10 years leading up to the filing of this MYRP, our sales declined at a compound annual growth rate of more than 1% every year, nearly double the rate of sales decline for other Minnesota utilities, and more than 20 times the rate of sales declines for other utilities nationally. The result is that our sales in 2024 were almost 10% lower than our sales 10 years earlier. The decline in our sales was experienced across all of our customer classes, and this sales decline occurred despite an increase in the overall number of customers that we serve. This is a good thing. The state and the commission have promoted conservation now for decades because conservation provides bill savings and other benefits to utility customers. And we believe that our efforts in promoting conservation have been extremely successful. In 2024 alone, our conservation efforts achieved over 500 gigawatt hours of electric savings, representing 1.9% of our sales and $411 million in net benefit to our electric customers. But what that decline in sales also means is that the company's fixed costs have needed to be recovered across fewer and fewer sales over time, which puts upward pressure on the need for rate increases. Excuse me. But what our data shows is that this upward pressure on rates has not resulted in higher growth in our customer bills when compared to other utilities. And to put the magnitude of this difference in context, in the 10 years leading up to our MYRP, our customer bills grew at a compound annual growth rate of less than 1% per year. This rate of growth for our customers is less than a third of what customers of other Minnesota utilities experienced on average, and it is also substantially less than other utilities nationally and throughout the upper Midwest. Likewise, the revenue taken in by the company during these 10 years grew at approximately half the compound annual growth rate of other utilities in Minnesota, while also trailing other utilities nationally and across the upper Midwest. In short, the conservation and declining sales to our customers have resulted in significantly lower bill growth for our customers and lower revenue growth for the company while compared to our peers, even if it has contributed to the need for increases to our base rates that we charge. Second, several parties have focused on the unique challenges that some of our customers face in affording their electric service as a basis to artificially hold our rates down and not provide the company with rates that are based on our necessary cost of service. We recognize the importance of assisting those customers who need help paying for their electric bills, and we share in this goal. In this case, we have discussed our ongoing efforts to assist these customers, and we offer a new program here to help low-income customers who have built up arrearages to pay down these balances. We're open to continued discussions of how we can potentially provide additional assistance to these low-income and struggling customers. The key to ensuring affordability, the key to ensuring affordability of our service for all of our customers is targeting those customers who face an affordability challenge, rather than setting rates for all of our customers at a level that does not allow the company to recover its necessary costs, which is neither reasonable nor consistent with applicable law. Finally, we recognize there's a level of judgment involved in reaching a final determination in this case. However, contrary to the argument of the Office of the Attorney General in this case, the law is clear that setting the revenue requirement is a quasi-judicial determination that is based on record evidence and fact-based assessment of the utility's necessary costs of providing customers with adequate, efficient, and reasonable service. Likewise, there's nothing in the law that allows the Commission to do what the Department of Commerce suggests here, essentially ignore the record evidence of the utility's cost to provide service and instead set the utility's rates based on a generic conclusion on whether the utility is financially healthy. In fact, the Minnesota Court of Appeals has explicitly rejected this argument. The ALJ properly rejected these arguments and wrote a thorough report based on his application of the facts to the law. At a high level, the ALJ's report accepts a number of reductions that the company already made to its requested increase throughout this case and recommended further significant reductions. At the beginning of this case, the company sought a final rate increase totaling approximately $490 million spread over a 2-year period. Before the testimony of other parties was filed, the company reduced this final amount by approximately $17 million by incorporating changes and corrections to its wildfire and employee expenses, interchange revenues and expenses, and proposing the Residential Arrearage Management, or RAMP, program that will provide support to our customers that are behind on their electric bills. In rebuttal testimony, after receiving the direct testimony of interveners, the company removed an additional $108 million from its final request by incorporating more than 20 adjustments to reflect updated information and acceptance of other parties' direct testimony recommendations. The ALJ report accepted all of these adjustments agreed to by the company and proposed by the company throughout this case, and recommended further reductions that lower the company's proposed increase by another $118 million. All told, the ALJ's report would result in base rate increases averaging less than 3.5% over 2025 and 2026, and set our final 2026 rate increase at approximately 50% of the company's initial request in November of 24. It would also remove approximately 57% of the increased revenue over the 2-year period of the MYRP as compared to what the company initially requested. I'm sorry, the revenue increase over that period. This is obviously a substantial reduction from the company's requests in this case. And while we recognize that it is common for utilities to receive less than their requested increases, we disagree with several of the ALJ's specific adjustments as discussed in our exceptions to this report. And we have significant concerns that additional meaningful downward adjustments would be detrimental to the company's efforts to continue providing safe, reliable, and reasonable service for our customers. So we ask that you consider the record in this case and set rates that allow the company to recover the necessary costs that we are incurring to provide reasonable service to our customers, and that allows us to continue raising the capital needed to benefit our customers. I don't plan to go through specific decision options because they're already reflected in the staff's briefing papers, and we filed the letter in the last few days outlining any concerns and changes that we had. But we again thank you and your staff for the efforts you've put in to considering this case and for the opportunity to speak to you today. And so we're available for questions.
Thanks, Mr. Dobson. Next is the Xcel Large Industrials. Good morning. Please state your name for the record.
Good morning, Madam Chair, Commissioners. Andrew Moratska, Stoll Reeves on behalf of the Xcel Large Industrials. With me, I believe, on the WebEx are the witnesses that testified on behalf of XLI, Billy LeConte and Jonathan Lee. Just noting for the Commissioners' benefits, if there are questions for Ms. LeConte, she's available till about 1 p.m. and then has another engagement. But will be available next week. Sorry, I'm trying to remember to read the little stick-it note here. Although XLI covered a number of issues in this case, I want to use my time today to address 4 key points. Xcel's uncompetitive electric rates, Xcel's unacceptable customer service, the ALJ's incorrect valuation of Xcel's ROE, and the disconnect between the ALJ's conclusions on class cost service study issues and revenue allocation issues. In addition to the company's overview, the company's unsustainably high rates and bills for the C&I demand class, and the company's abysmal customer service and billing issues are also important context for this case. Regarding rates and bills, it is undisputed that as of the year 2024, the company's industrial rates are about 18% above the national average. This point was conceded by Xcel's witness during cross-examination and was based on Xcel's analysis. Also, no party disputed that XLI's analysis on bills that shows the company's request, if approved, would exacerbate the situation and drive costs for industrial customers from 13% to 22% above the national average. To be sure, Xcel's existing rates, even without any increase in this case, are inconsistent with state energy policy. With respect to the company's billing and customer service, the record reflects that C&I customers have experienced significant billing delays and billing errors. For example, in one instance, a customer received no invoices for 4 months. and when that customer did receive an invoice, it was incorrect. In another instance, a customer received an erroneous invoice for $37.4 million. And in a recent compliance filing, the company admitted that there has been a 155% increase in the average monthly number of C&I billing errors by controllable factors from 2023 to 2025. These billing errors make it exceedingly difficult for property managers to budget and bill their lessees. The company's decades-long earnings per share growth should not coincide with uncompetitive electric rates and poor customer service. The Commission should modify the ALJ report accordingly and resolve any reasonableness questions regarding the rate setting in favor of the consumer, consistent with state law. The modifications that XLI proposes are covered in detail in the exceptions, and I will cover 3 in my time today. The first modification that XLI proposes is to recognize that more than just a two-growth DCF methodology guides the Commission's broad authority in establishing the ROE. Looking at applicable law and the parties' testimony, establishing ROE is a pragmatic exercise with subjective judgment applied. The company acknowledged, as do the other parties, that the Commission is required to establish a cost of capital that is adequate to allow the company to attract capital necessary to provide safe and reliable service, sufficient to ensure the company's ability to maintain its financial integrity, and comparable to returns on investments in other enterprises having similar risks. The ALJ's focus on the last factor generally, and the two-growth DCF analysis specifically, misses the critical distinctions and overlooks the adequacy and sufficiency factors the company acknowledges are applicable. On the adequacy factor, the current ROE of 9.25% has been more than adequate to attract capital. The company admitted in this proceeding on the record that it has not experienced any difficulties accessing the capital markets. And earning per share and net income have continued to increase dramatically over the past decade, with the company stock reaching a record high. On financial integrity factor, XLI put in unrefuted analysis that shows the company's financial integrity would not be negatively impacted by an 8.96% ROE as recommended by XLI. These two factors were not addressed in the ALJ's report, and there is insufficient evidence to support a 9.8% ROE as recommended by the ALJ. The second modification that XLI proposes is to reduce the company's request for full recovery of its customer care O&M. As already noted, the record here and related investigation underscore the alarming data on billing and customer service issues. The company should not, in this proceeding, receive the benefit of full recovery of this expense when it so egregiously failed to deliver basic customer service or accurate bills. The Commission should modify the ALJ report and remove this expense from the company's revenue requirement. I want to take a moment to briefly address the standard that the company discussed just momentarily ago. Both of these revenue requirement issue adjustments are considered under long-standing case law. This case law is outlined on pages 6 to 7 of XLI's exceptions, and I'd like to point the Commission to the In Re NSP case, which states, quote, by merely showing that it has incurred or may hypothetically incur expenses, the utility does not necessarily meet its burden of demonstrating that it is just and reasonable that the ratepayers bear the cost of those expenses, end quote. The case went on to say, the task of the MPUC is not so much concerned with the sufficiency and credibility of the evidence as it is concerned with whether the evidence submitted, even if true, justifies the conclusion sought by the petitioning utility when considered together with the Commission's statutory responsibility to enforce the state's public policy that retail consumers of utility services shall be furnished such services at reasonable rates. Any indication or implication that the Commission doesn't have the authority to take these considerations into effect when setting rates is simply untrue. The final modification XLI wants to discuss today is revenue allocation. There are multiple aspects of the record that support this modification. The first relates to the company's class cost of service study methodology. As detailed in the record, 3 states have specifically rejected the company's stratification methodology. That would include Michigan, Florida, and Texas. In fact, the record shows that the company's stratification methodology is obsolete and that the Commission should move towards a methodology utilized in Minnesota and 6 other states. But the second and more important relates to the use of the class cost of service studies in the record. As a starting point, even assuming the company's CCOSS is reasonable, the company's proposal does not reduce subsidies paid by the C&I demand class. In fact, as XLI's analysis shows, the company's revenue allocation proposal increases the subsidy. This is set forth in Table 6 of XLI's exceptions. Moreover, the ALJ's recommended revenue allocation is remarkably inconsistent with his CCOSS findings. Despite asserting that the OAG's CCOSS should be given significantly less weight than the others, the ALJ's recommended revenue apportionment results in giving the OAG's CCOSS's the most weight. And despite finding that the Xcel's and DOC's hybrid model should be given the most weight, the ALJ's recommended revenue apportionment gives those class cost of service studies no weight. Now, continuing to endorse or give greater weight to results-driven class cost of service studies that favor smaller load and lower load factor customers, and then deviating from those same studies for the benefit of those smaller load and load factor customers, has resulted in discrepancies between the company's rates and bills and the national average, as I discussed at the outset. XLI respectfully requests that the Commission pursue elimination of the long-standing interclass subsidies and set rates accordingly. That concludes, Commissioners, my comments. I'm happy to walk through the decision options or follow up with a filing if that's helpful.
Do they deviate from what is already filed or in the briefing papers? And if they do, then please file that today or tomorrow, just for clarity.
Happy to do that. There is one, Your Honor, or excuse me, Commissioner, Chair. Thank you.
Great.
Yes.
Thank you, Mr. Maratzka. Next is the Suburban Rate Authority. Mr. Sathi, good morning. You can use that seat or whatever you'd like.
Well, they cleared it out for you. So.
Stephen, thank you very much. Chair Sieben, members of the Public Utilities Commission, thank you very much. I am Joe Sathi here on behalf of the Suburban Rate Authority with the law firm of Kennedy and Graven. The Suburban Rate Authority consists of 30 suburban communities representing about 1 million folks here in Minnesota. Now, these communities vary in size and stretch from Bloomington to Lauderdale, I like to say from Maple Grove to Maplewood. And within these communities, there's varying levels of infrastructure related to streetlights, with our urban core communities having a higher rate of overhead fed streetlights and further suburbs with a higher percentage of underground fed streetlights. And that's important because the Suburban Rate Authority is here to talk about street lighting. In the most recent past electric case, the SRA and Xcel entered a stipulation in which we agreed that Xcel would come back in this rate case with a more simplified design for streetlights. And while that is generally achieved in this case, with rates for street lighting overall moving more towards direct costs, the SRA is still somewhat concerned about increases to rates for street lighting customers, especially those communities with overhead, with a larger percentage of overhead lighting. To that end, the SRA's expert Jim Bride, has recommended one inter-class adjustment that would ameliorate some of these impacts to our customers with overhead-fed lights. And this is provided in decision option 5026. Again, to ameliorate some of the impacts of the increases, the SRA also supports decision option 4010 regarding the use of the D10S allocator or an allocator that uses a peak summer method. The SRA appreciates the opportunity to participate in this hearing and will stand for any questions today.
Thank you very much, Mr. Sathi. And next is George Shardlow with the Energy Sense Coalition. Good morning, Mr. Shardlow. Please state your name for the record.
Thank you, Madam Chair. George Shardlow with the Energy Sense Coalition. We intervened in this matter to advocate on behalf of Xcel's low-income electric customers. I want to begin by thanking the company for its openness to extend auto-enroll in the Power On affordability program. We administer both Power On and Xcel's gas affordability program, which already has auto-enroll and has been very effective in expanding participation. The two other items I'll note that are of concern and interest to ECC are the conversation about late fees and reconnection fees. Candidly, on late fees, we were torn because, as commissioners are aware, the company has brought forth a ramp proposal funded by late fees that we believe would serve a missing need of folks up to 80% AMI, as many customers continue to struggle with arrears. With that being said, we were swayed and took note of other parties' commentary that late fees run the risk of being a regressive funding source, especially if, as we would suspect, low-income customers are the likeliest to fall behind. And so for that reason, we support threading the needle. We believe the ramp proposal should be approved, but provisions like limiting late fees to the cost of interest to minimize those impacts, and of course welcome ongoing conversation about additional funding sources in the future. On reconnection fees, I want to acknowledge that this is now obviously a complicated issue since we filed our comments. Changes have been made to the company's remote disconnection variants. At the time when we filed our comments supporting waiving reconnection fees, candidly, we were concerned. We were confused about what the fees even funded, especially when other utilities do not charge reconnection fees for remote reconnection. It may be the case that there are so many moving pieces that this now becomes a topic of conversation for the service quality docket or other forums. But ultimately, as a guiding principle, I would just close with 2 points. First, I think it's important to categorize the arguments that we make about fees. And I think in the case of late fees, it tends to be an argument about behavioral psychology. And in the case of reconnections, it's cost allocation. And I think in either case, at minimum, we should make sure that the arguments we make are substantiated. We took note of evidence that Cobb entered into the record from Kentucky that disputes whether the behavioral motivation of late fees actually does increase timely payments. And certainly bear that in mind. And we also understand that kind of conversely, the argument around reconnection fees was more around cost causation and the fact that the customer being reconnected is the one causing the cost and should therefore bear it. What I'll close by saying is that as the administrator of Power On and GAP, it is our belief, and it has been our experience, that when people receive a bill that they can afford, they pay it. The payment frequency of GAP participants has consistently outpaced payment frequency among LIHEAP-only customers. And in the end, that means those customers are paying more into the system than they would if they were simply disconnected and potentially evicted and thrown out of the system entirely. And so as we consider both behavioral psychology and cost causation, I think it would be a sort of a Pyrrhic victory to impose additional reconnection costs on low-income customers, but then pass on disconnection and collection costs to the rest of ratepayers when those customers fall behind. In the end, whatever argument we accept on fees and whatever decision the Commission makes, we hope that we collectively can be clear about what that argument is and what sort of reporting requirements would be necessary to make sure that we're not trafficking in truisms, but substantiating the assumptions that guide our policy. Thank you.
Thank you, Mr. Shardlow. Next is the joint interveners. Good morning. Please state your name for the record.
Good morning. My name is Erica McConnell, and I'm an attorney with the Environmental Law and Policy Center, and I represent the joint interveners in this case, who are ELPC, Cooperative Energy Futures, Minnesota Interfaith Power and Light, and Vote Solar. Thank you for the chance to speak this morning, and thanks also to staff for all of your work on the extensive briefing papers in this case. Our intervention in this case builds off of the Just Solar Coalition's intervention in Xcel's last rate case, which involved a very similar group of organizations, as well as our engagement in other related proceedings, including Xcel's Integrated Distribution Plan and Integrated Resources Plan, among others. In Xcel's last rate case, we were pleased that the Commission recognized the importance of energy justice tenets in its proceedings, including general rate cases, and found that these tenets were relevant to setting rates in that case. The tenets of energy justice are likewise relevant in this rate case proceeding. The joint interveners have continued to center energy justice, equity, and affordability in our advocacy in this case. Likewise, we have also continued to advocate for leveraging distributed energy resources on the distribution system. Improving clean DER access is critical to enabling a more just, equitable, and resilient electric system. And optimizing the use of DERs on the system can drive down costs for all ratepayers and promote affordability. With this framing in mind, I'd like to highlight two of our core issues in this case. First, joint interveners propose 3 recommendations that highlight the important role that Xcel's Integrated Distribution Plan plays in relation to its rate cases. Namely, 1, we recommended the integration of equity considerations in distribution planning, similar to what utilities in Michigan have done, and that's captured in decision option 1107 or alternatively 1105. 2, we recommended denial of recovery for the company's targeted undergrounding investments until the Commission has reviewed the company's targeted undergrounding plans and proposed budgets in its pending IDP, and that's in decision option 1101. And 3, we recommended requiring a Minnesota-based wildfire risk analysis and other further justification of the company's wildfire mitigation plans in the IDP. And that's captured in decision options 1021 and 1039, which are the same. We appreciated staff's supportive discussion of these recommendations in the briefing papers. The common theme across them is the key role that the IDP plays in supporting and justifying cost recovery for distribution spending in rate cases like this one. While the rate case is where the Commission evaluates and approves cost recovery for Xcel's distribution investments, the IDP is where the Commission can interrogate and improve Xcel's planning and decision-making before it has made those investments, to make sure the company's plans remain aligned with the Commission's public interest goals, including those related to equity and affordability. Joint interveners urge the Commission to adopt the decision options I just mentioned to help ensure the IDP plays this critical role. Second, joint interveners proposed a process to establish a universal low-income rate under the same legal authority the Commission used to approve the low usage affordability credit, or LUAC, in the last rate case. In this case, we and other parties showed that customers are facing energy affordability challenges, and involuntary disconnections in Xcel's service territory have continued to increase, despite the important efforts to improve the disconnection process. At the same time, existing affordability programs, which are critical and which we support, are reaching only a portion of eligible low-income customers and those with high energy burdens. This limited reach and persistent energy insecurity are evidence of the need for a universal low-income rate that can provide a more comprehensive solution. To be clear, and this was in the letter that we filed on Tuesday, joint interveners have not recommended a specific rate in this case. Rather, we urge the Commission to adopt decision option 5022 to instigate a process to establish a low-income rate. During this process, stakeholders can discuss the concerns raised by Xcel and the department and otherwise develop evidence related to the benefits, costs, behavior impacts, cost allocation, and rate implications of a low-income rate. Thanks again for the opportunity to speak today, and I look forward to answering any questions you may have.
Thank you, Ms. McConnell. My understanding is Walmart, who is a formal party, waived their 5 minutes. Is there anyone on from Walmart that wants to affirm that, or you have Walmart has another option to speak now if they'd like to. Next then is Brian Edstrom with the Citizens Utility Board. Good morning. Please state your name for the record.
Good morning, Chair Sieben and Commissioners. My name is Brian Edstrom, and I'm here representing the Citizens Utility Board of Minnesota. Also here with me are my CUB colleagues Brandon Crawford and Olivia Carroll, and CUB's expert witness, Dr. Steve Keim. Each of us are available for questions, and I also want to thank the Commission staff for the very thorough briefing papers and the Commissioners for giving us some additional time to speak today. I want to begin my opening statement by reflecting a bit on the public participation in this docket. I think after a long proceeding like this, it's easy to get focused on the details of the complex record and the nuances of legal and policy arguments various parties have put forward. But it's also important to keep in mind the consequences that decisions like this will have, not just for the company, but for real Minnesotans who have real concerns about their rising utility bills. CUB reviewed and categorized around 4,000 public comments filed on this docket. We stopped at 4,000 because we lacked the capacity to keep up. By our account, that number has now risen to something around 8,600 public comments. This level of public engagement reflects a deep anxiety and concern about ratepayers' ability to afford their increasing bills. Over half of the comments CUB reviewed also reflect a growing frustration over being asked to pay more in rates as Xcel continues to report high corporate profits and generous compensation paid to its top executives. While we appreciate that the Commission serves an important role in ensuring Xcel has adequate revenue to provide safe and reliable service, the Commission, of course, also provides needed protection to ensure ratepayers are not charged more than is just or reasonable for that service. I know and appreciate that public participation is important to this Commission, and I ask that you please keep in mind the perspectives of the many who participated in this docket as you consider the record before you today. With that, I'll turn to the core arguments CUB introduced in this proceeding. First, we recommend that the Commission lower Xcel's authorized ROE. Xcel claims, citing the Supreme Court's Hope and Bluefield decisions, that it requires a 10.3% ROE, which is higher than the ROE authorized for any other utility operating in Minnesota. This, they claim, is in order to attract capital, maintain financial integrity and creditworthiness, and earn a return commensurate with peers of similar risk. If approved, this ROE increase alone would add around $100 million per year to the company's revenue requirement. In the time since the Commission authorized a 9.25% ROE in Xcel's last electric rate case, XCI's stock price hit an all-time record high. Its annual net earnings have increased year over year, rising to $1.94 billion in 2024. XCI has continued its two-decade trend of annual dividend increases, and XCI and Northern States Power Company have raised billions of dollars in debt and equity issuances. As Mr. Moratzka noted earlier, in response to a discovery request, a company representative flatly stated, and I quote, "NSPM has not experienced difficulties accessing capital markets since its last litigated base rate case." This strong financial performance has all occurred while the company has had an authorized ROE of 9.25%. Against this backdrop, the Commission should be deeply skeptical of the company's ROE request. The Hope and Bluefield decisions do not require ratepayers to write a blank check to fund whatever purported ROE figure emerges from Xcel's modeling results. Rather, Hope, Bluefield, and other precedential decisions establish parameters for determining a reasonable ROE, one that balances shareholders' right to earn a reasonable return against ratepayers' protected interest in paying just and reasonable rates. These decisions call for the Commission to use its judgment in considering a variety of factors, to not disregard the consumer interest, and to focus on the end result of its decision rather than the methods employed to get there. While models are helpful tools to estimate a utility's cost of equity, they are not a substitute for the Commission's judgment when establishing a fair, authorized return on equity. Expert witnesses Keim, Adonisio, and LeConte, who collectively have over 90 years of experience doing this work, provided well-supported testimony showing that witness NOAC's analysis is flawed and produces an inflated ROE recommendation. In combination, these witnesses, along with at least 5 parties who discussed ROE in their briefs, also provide substantial evidence and record support for lowering the company's ROE, or at least holding it flat at 9.25. CUB continues to recommend that the Commission establish a 9.0% ROE for the reasons discussed in Dr. Keim's testimony in our briefs, and we firmly believe this would reasonably balance the rights of Xcel's shareholders and ratepayers, thereby complying with the Hope and Bluefield standards. On late payment fees, CUB also recommends that the Commission eliminate late payment fees, or at least modify how they are assessed. CUB witness Levinson Falk presented compelling evidence demonstrating that late payment fees do not alter customers' payment behaviors, but instead impose a financial burden on vulnerable households. Moreover, the 18% annual late payment fee assessed by the company is 3.3 times greater than the costs incurred by the company to service arrearage balances. The company has not justified either the need for penalizing customers already struggling to pay or that the penalty amount it imposes is reasonable under cost causation principles. Relatedly, while CUMP appreciates the goal of the company's RAMP program, we do not support its funding mechanism. Funding RAMP through late payment fees creates an illogical cycle where the customers that might benefit from RAMP must also pay penalties to fund it. Worse, households enrolled in the Energy Assistance Program are explicitly not eligible for RAMP, meaning they could be assessed late payment fees used to fund a relief program they are then barred from accessing. To be clear, our primary recommendation is that late fee payments be eliminated, and if the Commission adopts that recommendation, we believe that also requires denying the RAMP program in its current form. In the alternative, and if the Commission chooses not to fully eliminate late payment fees, we recommend that those fees be set at the interest rate incurred by Xcel to service residential customers' past due balances. This would reduce late fees from 1.5% to 0.5% per month and would be a step in the right direction. As part of this alternative, we also recommend that such fees be waived for low-income households. And on reconnection fees, we recommend that the Commission eliminate reconnection fees for residential customers. Over the past few years, Xcel's disconnection rates have risen dramatically. In 2024, the company involuntarily disconnected utility service to 52,549 residential customers, more than all other rate-regulated utilities combined. The challenges ratepayers experience when they have their service disconnected is made worse when they have to pay down their arrears plus a reconnection fee. We recognize that eliminating these fees might modestly increase expenses passed through to all ratepayers by about $500,000 annually, or about 40 cents per customer per year. However, eliminating reconnection fees could bolster substantial ratepayer value, from cutting short the negative effects of disconnection to lowering arrears accumulation and mitigating associated bad debt expense. These benefits are wide-ranging and are likely to outweigh the nominal expense that would be assessed to all customers. If the Commission opts not to eliminate reconnection fees in their entirety, we recommend that the Commission take other steps that would reduce harm to those ratepayers who are most vulnerable. Namely, we recommend that the Commission waive fees for all low-income households and exclude labor costs from its reconnection fee calculation to eliminate the possibility of double recovery of those costs. In conclusion, I'll note CUB has proposed several modifications to the ALJ report that clarify the record on the above topics and our perspective on them. The briefing papers generally capture these recommended recommended modifications, though we will consider filing a letter to address any concerns there. And otherwise, the briefing papers accurately depict the decision options that CUB supports. Thank you.
Thank you, Mr. Edstrom. Next is Peter Schultz from the Office of the Attorney General Residential Utilities Division.
Good morning, Madam Chair and Commissioners. Peter Schultz with the Office of the Attorney General Residential Utilities Division. With me today also are my colleagues, Assistant Attorney Generals Joey Cherney and Wendy Raymond, and two of our analysts, Shua Lee and Helen Sharber. Catherine Hinderly also provided testimony in this case on executive compensation, among other things. She is not available today as she is traveling, but will be here next week. Rather than walk you through every one of our issues or decision options, I wanted to step back and ask you to consider two questions. I'll try to stay close to the mic here because I think this is one of the ones that is a little not sensitive. So the two questions are, why are we here and who benefits? First, why are we here? Most obviously, we're here because Xcel wants to take an extra $365 million per year from its captive customers. As you've already heard, almost a third of that, or $100 million, is just so that Xcel can increase the profit that its shareholders receive for investing in Xcel's business. And Xcel is seeking to increase ROE at the same time as its shareholders are already seeing dazzling financial performance from the company. You've heard several data points about this from other parties. I just want to highlight two. First, as the department highlighted in its motion to take notice of Xcel's April 30th 8K, the company's net income in Q1 of this year was up more than 15% compared to Q1 of last year. The second data point is that Xcel's annual reports have often touted its consistent dividend growth each year for the past 2 decades plus. I'll say that again, consistent dividend growth every year for more than 2 decades. Any increase that the Commission allows here will pile on top of the $1 billion in cumulative increases approximately that Xcel has received since 2011. In that time, Xcel requested a rate increase in every year but one. Yearly rate increases, dazzling profits. Those two things are not a coincidence. While Xcel's shareholders enjoy massive profits, many of its ratepayers are struggling, as evidenced by the more than 7,000 or maybe even more than 8,000 public comments that have been filed. And that's a historic number by my count. That's over 7,000 people that have found this rate increase so impactful to them that they chose to take time out of their personal lives to share their concerns with you. The vast majority of those comments oppose Xcel's rate increase. Many commenters share in detail what the proposed increase would mean for them or their neighbors, forcing tough choices about what necessities to go without if an increase is approved. Others highlight the injustice of having their bank accounts drawn down just to pad corporate profits or offer lucrative executive salaries. And still others express frustration that their efforts to conserve energy, such as buying efficient appliances and turning down thermostats, are being rewarded with yet another rate increase. And the fact that, as you heard Xcel say earlier, its sales are declining is cold comfort to these customers who can't further, they've made efforts and they can't really further reduce their usage. So I urge the commissioners to review or re-review those comments as much as you can before next Thursday. Judge Meyer did a great job summarizing them, but there's nothing like going to the source to hear from Minnesotans directly about their concerns in their own words. And it's not just households that are struggling. Several business owners filed comments opposing the increase, including one small business owner who had to close up shop due to rising energy costs. On this point, I want to highlight a key feature of the OAG's revenue apportionment, which the ALJ recommends you adopt. Every class cost of service study in the record agreed on one point. The small commercial class is already paying more than their cost of service. No matter how you slice it, small businesses are overpaying. We recommend that the small commercial class receive a zero increase at Xcel's rebuttal revenue requirement. And if the Commission approves less than Xcel is requesting, this class's revenue responsibility would decrease. And as you heard earlier from Counsel for XLI, our revenue apportionment actually recommends an increase that is higher than our class cost of service study and some others would indicate for the small commercial class. Even a zero increase is more than is indicated. So by adopting the OAG's apportionment, you can mitigate the harm that small business owners have been experiencing from inflation to economic downturn to Operation Metro Surge. So again, ask yourself, why are we here when Xcel has only missed a single opportunity to increase its rates in the last 15 years and is already raking in huge profits? We're here because for Xcel and its shareholders, that's not enough, even when many of its fellow Minnesotans are suffering. The second question I want you to consider is who benefits? And there's really two parts to this question. First, who benefits from the rate case overall, and who benefits from Xcel incurring the individual expenses that make up the overall increase that Xcel allegedly needs. It's pretty clear what shareholders get out of this case: more cash in Xcel's hands to pay dividends. But what are ratepayers getting? Better service? Xcel is already required by law to maintain reliable service and is subject to performance penalties if it fails to do so. Ratepayers can potentially benefit from a financially healthy utility that is better positioned to provide reliable service. But Xcel's SEC filings show that it is already more than financially sound. It's blowing just about every profit metric out of the water. Finally, I want to suggest to you that the who benefits question is not just a way to look at the case as a whole, it's a lens through which to analyze individual issues. Simply put, whether shareholders or ratepayers benefit from Xcel incurring a particular expense is a key policy factor that you should consider in deciding whether ratepayers should have to bear that cost. Contrary to what I think we heard Xcel's counsel say earlier, the Minnesota Supreme Court has been crystal clear on this point. Your revenue requirement decisions, which include the discrete expenses that make up the revenue requirement, have both a judicial and a legislative component. The judicial component is, okay, did Xcel actually incur or will it incur this cost in the amount claimed? The legislative component is the public policy question. Should ratepayers or shareholders bear the burden of the claimed expense? This is black letter utility law in Minnesota. And we maintain that who benefits from the expense is clearly relevant to the question of who should pay for it. And the OAG's recommendations on several issues follow this theme, as we'll talk about, I'm sure, later. But these issues include, but are not limited to, top 10 executive compensation, rate case expenses, EEI dues, and even some of our CCOSS recommendations, such as AMI classification. Xcel's rate hike will mean another increase to household energy bills when Minnesotans are already facing rising costs everywhere and struggling to afford their lives. It will also mean another blow to our small businesses in a very challenging economy. As you're considering whether Xcel's request to raise rates is just and reasonable, I again encourage you to ask, why are we here when Xcel is thriving? Why are we here after a decade and a half of near annual rate increases? And who benefits both from the overall rate increase and from the specific line items that have been challenged? We ask the Commission to ensure that ratepayers are benefiting from the cost that they're being asked to pay. And where Xcel has failed to show this, we ask that you grant the OAG's adjustments by adopting the ALJ's report as modified by our exceptions. Thank you for the opportunity to speak, and me and my colleagues will be available for questions.
Thank you very much. The final commenter is the Department of Commerce, Division of Energy Resources. Welcome, Mr. Dornfeld.
Good morning, Chair Sieben, Commissioners. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Department of Commerce. I'm joined by my colleagues, Assistant Attorneys General Catherine Arnold and Amrit Hundal. Also, many of the department analysts who've worked on this case are available online, and of course, Ms. Campbell is available here, and she usually has an answer to most questions. I think the place to start is with the Commission's legal obligations in this case. In a rate case, the Commission's sole legal obligation is to set a non-confiscatory rate. A rate becomes confiscatory when the total effect of the Commission's order would jeopardize the utility's financial health. As you heard Mr. Moratzka talk about a little earlier, the utility's financial health is only put at risk when a rate prevents a utility from maintaining strong credit, attracting capital, or rewarding investors for the risks they accept. And I know that Mr. Dobson and Xcel don't agree that that's the legal framework, but I want to assure you that Mr. Moratzka and I didn't make that up. It comes from the Duquesne Light case, which is a U.S. Supreme Court case from the 80s, and the Minnesota Court of Appeals applying that framework in the Quest-Tofte Exchange case. I'd encourage the commissioners to look that up. So with that framework in mind, the Commission has no duty to award the utility with its preferred outcome. Instead, the Commission is charged with reaching a result that is just and reasonable for the utility and the public, as you heard some of my colleagues discuss this morning. So that leaves us with rate making as a pragmatic task where the utility has the burden to show that every dollar of its request is necessary to provide safe and reliable service. And as the record demonstrates, against every measure, Xcel is thriving under its existing rates. Xcel's performance reflects strength, stability, and steady growth. Since its last rate case, Xcel has repeatedly raised money in the debt and equity markets on favorable terms. In 2024, NSPM issued $700 million in new debt. Last year, NSPM issued another $1.1 billion in new debt. And Xcel Energy, Inc. raised $1.2 billion in new equity over the same period. Credit rating agencies gave these issuances A ratings and stable outlooks, which tells us that investors see low risk, steady returns, and strong future performance for Xcel. Xcel's long-term history tells the same story. Between 2010 and 2024, NSPM's earnings per share rose 135%, and last year, Xcel stock reached an all-time high. Xcel's most recent numbers show the same trend. In the first quarter of this year, Xcel earned $556 million, up from $483 million the same quarter of 2025. It raised its dividend for the 23rd straight year, and it reported $5.3 billion in liquidity across the company. NSPM also showed strong credit and cash positions and issued another $1.2 billion in first mortgage bonds at competitive rates. All of these are unmistakable signs of financial strength. They describe a company with access to capital, steady earnings, strong investor confidence, and reliable growth. This is not a company struggling under current rates. It's a company flourishing under them. Xcel's financial success stands in stark contrast to the strain its customers face. While Xcel posts record earnings and enjoys low-cost financing, many households and businesses struggle to afford basic service. Since 2005, Xcel's rates have risen 98%, almost twice the rate of inflation. And by 2023, the most recent year available at the time of direct, Xcel's rates were 3.5 cents higher than Minnesota Power's and 5.5 cents higher than Otter Tail Power's. After 20 years of steady increases, Xcel's industrial rates sit at least 13% above the national average. And for residential customers, the picture is worse. About 13% of Xcel's residential customers spend more than 6% of their income on energy, a commonly recognized threshold for excessive energy burden. And as the thousands of public comments demonstrate, many households are sacrificing on food, medicine, and other essentials to keep the lights on. And recent inflation will only make these challenges worse. Xcel attempts to deflect from this reality by pointing to average monthly bills and the average customer. But averages hide more than they reveal. No customer is average. Many households pay far more than the midpoint. Put another way, a lake might be on average 3 feet deep, but a sudden 30-foot drop-off will still drown you. And the record shows that many customers are struggling to stay above the water. Rising disconnections, rising arrearages, and widening gaps between Xcel's rates and its peers all tell the same story. Customers are struggling, and they're struggling right now. Xcel's financial strength does not justify increasing the burden further. Any rate increase now would be a windfall for Xcel at a time when its customers can least afford it. The constitutional standard neither entitles Xcel to the highest possible return nor insulation from ordinary business risk. Xcel's return on equity proposal is particularly egregious. Despite growing profits, Xcel claims it needs a 105 basis point ROE increase to 10.3%. That increase alone would add more than $103 million to customer bills. Put simply, nearly 1/3 of Xcel's claimed revenue shortfall comes not from cost pressures, but from a desire to boost investor rewards. But the evidence does not support that request. Sound multi-stage discounted cash flow modeling establishes that Xcel's cost of equity was about 8.82% at the time of direct testimony and fell to 8.35% at the time of surrebuttal. Those numbers align with or exceed estimates from major research firms, investment banks, and respected financial surveys. Keeping Xcel's current 9.25% authorized ROE is conservative in Xcel's favor. It's higher than 21 of the 27 independent cost of equity estimates in the record. It exceeds recent treasury yields and the cost of equity trend for proxy companies. It also exceeds what Xcel needs, as shown by its continued earnings growth, strong credit rating, and high investor confidence since the Commission's last rate case decision in July 2023. Xcel, of course, claims that an ROE increase is necessary based on its witness Joshua Novak's modeling. But his testimony in this case is not credible. Novak's firm, Concentric Energy Advisors, has testified for Xcel at least a dozen times in Minnesota since 2004. Over that period, interest rates have ranged from near 0% to about 5%, which suggests a range of economic conditions. But Concentric's recommendations remain firmly anchored around a 10.7 ROE. That pattern suggests a predetermined goal rather than objective analysis. The Commission has wisely never adopted a Concentric recommendation over that time, and it shouldn't start in this case either. Novak's own modeling also has been outcome determinative. In this case, Novak testified that ROEs generally track interest rates, but his recommendations don't reflect that testimony. Between 2020 and 2023, in other rate case proceedings, Novak recommended a 12.4% ROE for a utility when interest rates were around 2%. He also recommended a 10.35 ROE for a utility when rates were around 5%. And then when interest rates dropped back down to about 2%, he recommended a 10.8% ROE. Closer to home, Novak recommended both a 10.2 ROE and a 10.65 ROE in Xcel's last two gas rate cases, despite similar economic environments. These recommendations show that Novak's modeling results are not the product of reasoned judgment, but outcome determinative exercises intended to achieve a preferred outcome for a lucrative and long-time client. Novak's attack on the department's multi-stage DCF analysis in this case also are unprincipled. In this case, Novak claims that multi-stage DCFs are inappropriate for mature companies like utilities. But as recently as 2023, he urged the New York State Commission to adopt the multi-stage model because it solves major flaws in the two-stage DCF. Novak testified that the multi-stage DCF offers, quote, improvements over the two-stage model because it avoids the abrupt shift from the initial period to the perpetual growth period. Novak also previously supported using GDP as a long-term growth limit, as the department did here. He testified, quote, long-term estimates of GDP growth are commonly used in regulatory proceedings as a proxy for the long-term growth rate in the multi-stage DCF analysis. These points support the department's position here. The multi-stage model reflects how real companies grow. It avoids unrealistic jumps in growth rates. It ties long-term growth to a logical cap like GDP. It reflects transparent public data and aligns with accepted financial theory. Every credible method points to the same conclusion. Xcel's current 9.25 ROE exceeds the real cost of equity, and increasing Xcel's ROE further would shift millions from struggling customers to already well-compensated investors. As part of this rate case, Xcel also asked the Commission to sanction a legally unjustified return on pension trust assets. And so for this issue, I think it's important to start with the basics, and I hope you'll indulge a trip to 1L property law with me. Under common law trust principles, a trust creates a fiduciary relationship with respect to property. A trustee holds property for the benefit of another. And so this means when a company contributes money to a trust, it no longer owns that money. The trustee does. And the trustee has a legal obligation to use those funds to the exclusive benefit of the named beneficiary. So in this case, Xcel's employees, retirees, and their families. Here, it's undisputed that Xcel contributes pension funds to a trust, and that Xcel is neither a trustee nor a beneficiary. It does not own the funds. It only holds a contingent reversionary interest. Put more simply, that means a right to whatever remains if the trust someday ends and all pension obligations have been satisfied. So I think a simple example is helpful here. Imagine my will says that my brother gets my house if, when I die, I have no grandchildren. So that would mean Charlie has a property interest in my house, but today it's not worth very much. He can't live in my house, he can't sell it, he can't rent it, and he might not ever get my house. Everything depends on a future event that might not happen. And that's what Xcel's interest in the pension asset is right now. And so if Xcel has a contingent reversionary interest, the question that the Commission needs to consider is, what's the value of it today? And courts have grappled with these questions for a long time. And as a matter of law, they treat such interests as having, quote, no ascertainable value unless they're likely to be realized soon. And the reason for that conclusion is courts have decided that these interests are too uncertain, too remote, and too conditional to treat as a present property interest. And there's a 2020 federal court case that I think illustrates this well, discussed in our briefing. In that case, a plaintiff claimed rights in a property worth up to $12.3 million. But the court ruled that the plaintiff's contingent interest in the property was so speculative as to be less than the $75,000 threshold necessary to confer subject matter jurisdiction, and dismissed the case. And so, as this case illustrates, courts often treat such interests as worthless, and at most, they credit these interests with nominal value. The same reasoning applies here. Xcel admits that its pension trust plan is underfunded, and if the trust ended today, nothing would revert to the company. Xcel also admits it has no plan to terminate the trust soon, and that tells us that Xcel's interest has no meaningful present value. For rate-making purposes, Xcel is only entitled to a nominal return on $1,000 of rate base as a matter of law. Anything more than that would create a speculative future interest as a real asset, and the law does not allow that. In response, Xcel has argued that its pension trust asset is a regulatory asset, but only the Commission could create a regulatory asset, and that's a decision the Commission has not yet made. and the Commission generally only creates a regulatory asset when deferred accounting standards are met. And even if the Commission did choose to permit Xcel to create a regulatory asset, the regulatory asset shouldn't exceed the size of Xcel's real-world property interest. That's rate-making 101, that a utility can't earn on more than it owns. And appellate courts across the country have affirmed this principle, including the Minnesota Court of Appeals. In the People's Natural Gas rate case, the court upheld a Commission decision excluding contributions from rate base that Peoples made to a transmission provider for pipeline construction. Because the pipelines were not Peoples' utility property within the meaning of Chapter 216B, the company wasn't entitled to a return on them. These cases all establish that unless the utility owns the property, even property used in utility service, no return on it is required. Limiting a regulatory asset to reflect real-world property interests is also property law 101. Future estate holders such as Xcel have no present right to income or profits generated by the property in which they have a future interest. State law and the Court of Appeals require the Commission to give due consideration to mandatory pension plan contributions, but they don't require the Commission to blindly accept Xcel's valuation, characterization of its interest, or authorize an unjustified windfall. As part of this case, the Commission, Xcel also is seeking more than $15 million in ratepayer-funded pay and perks for its 10 highest-paid employees. In large part, Xcel relies on an argument that the Commission and the Court of Appeals rejected last time, that these salaries and fringe benefits are needed to attract and retain top talent. But Xcel hasn't shown how these outsized salaries benefit customers. It could not provide job descriptions or performance reviews for 8 of the 10 executives. It offered no evidence tying these salaries and benefits to better service, lower costs, or improved performance. Xcel likewise provided little to no explanation for why customers should fund executive physicals or financial tax and estate planning services for employees who could easily afford these services themselves. Nor did Xcel explain how ratepayers benefit from matching 401k contributions that are so large they exceed IRS limits. Hundreds of customers submitted comments opposing these outsized requests, and customers are understandably outraged about the prospect of spending millions of dollars on executive pay and perks when Xcel cannot show these executives are performing well or spending their time on ratepayer interests. The Commission has already rejected Xcel's line of reasoning once, and nothing in this record demonstrates a change in course. Xcel is only entitled to a rate that preserves its financial health, and the record demonstrates that Xcel is already meeting and exceeding that benchmark. Despite its continued prosperity, Xcel seeks to expand returns, assets, and compensation beyond what the law requires or the evidence supports, all at the expense of its captive customers. Each of these requests reflect the same pattern, shifting unnecessary costs and risks onto ratepayers at a time when many already face significant energy burdens. And the Commission's obligation is to real customers, not to the average customer Xcel constructs to justify shifting more costs onto already strained households and businesses. Accordingly, the responsible course and the minimum necessary to protect the public interest is to adopt the Department's recommended adjustments in full. Those adjustments are grounded in the evidence before you and reflect the pragmatic approach that rate-making requires. They help ensure customers are not overcharged for costs or returns the utility is not justified, while preserving Xcel's ability to deliver safe, reliable service and maintain investor confidence. Any increase today wouldn't safeguard Xcel's financial integrity. It would simply transfer more wealth from struggling customers to an already thriving utility. Thank you.
Thank you, Mr. Dornfeld. At this time, first I'll make a clarification that I think I covered with Mr. Maratska, but if parties have any corrections to the briefing papers, please file those by tomorrow. The staff intends to put together a compiled set of decision options for our use for next week, and we'd like those corrections by tomorrow. At this time, Commissioners, we'll move to the motions to take notice. So flipping to your decision options, at this time, I would move decision options 1004, 1006, and 1007, which grants the motions by the Department and the Office of the Attorney General to take notice of and admit into the record the specific 2025 SEC Form 8K, and the 2 Xcel filings. Under Minnesota statute, section 1460, agencies may take notice of judicially cognizable facts, and in addition may take notice of general, technical, or scientific facts within their specialized knowledge. We've had replies by parties on this, but is there any discussion from commissioners at this time on my motion?
Just, it was 10:04, 10:06, 10:07, right?
Correct. All in favor of my motion, please say aye.
Aye.
Aye. Opposed, the motion prevails. So at this time, we'll take a recess for lunch. I propose we come back at 12:30, and then we'll begin with commissioner questions. Anything before we recess? Great. We stand in recess until 12:30. The commission will come back from its recess, and as I stated before the break, we'll begin with questions from commissioners in volume 0. And in that volume, commissioners, just to refresh your memory, there are about 30 decision options, and it covers the legal standard, some disputed policy issues, and general housekeeping. Who would like to begin with questions in this section? Commissioner Partridge.
Thank you, Chair Sieben. So if Mr. Shardlow wouldn't mind coming up, I think I caught him off guard. My only question, I think, so far on this section is actually about the automatic enrollment for Power On. And my question is, I think, for Mr. Shardlow, which is, I'd like it if you could kind of help us understand what you think the automatic enrollment would do in terms of how many additional customers do you expect might be enrolled in Power On, and if you could also just kind of briefly remind us the benefit of Power On for customers who are enrolled.
Yes. Thank you, Madam Chair, Commissioner Partridge. I would have to phone a friend on the number. It's, of course, contingent on final LIHEAP applications, and so for this year, some of the final applications are still being processed. But in terms of the benefits, so long as, for starters, it comes with an arrearage forgiveness component. So, pardon me, any participant who comes in with arrears, we look at a 24-month repayment period, and either half of that or an additional 1% of their income, whichever is smaller, becomes their monthly arrearage payment, and each month that is paid, a matching credit is forgiven from their arrears. They cannot be disconnected while they're actively enrolled in the program. And on top of that, in addition to Power On, ECC also administers some of the company's home energy savings program, weatherization programs, and we intentionally do additional outreach to Power On and GAP participants to publicize those programs as well, to make sure they're making the most of efficiency programs as well.
Thank you, Mr. Shardlow. So I'll just kind of explain why I'm asking about this. So I'm mixing volumes here, so I apologize, Chair. I know in Volume 5, the joint interveners had proposed a universal low-income rate. I think there's some legal questions about whether that would be allowed under Minnesota statute. However, I am very much sympathetic to the argument that our current affordability programs are not meeting the full need. However, I think what you've proposed here, as you've laid it out, not only would bring a lot more people in, so I want to highlight that your proposal is to make the automatic enrollment available for everyone who's LIHEAP eligible and not just LIHEAP recipients. And so I think that this is a really significant step toward meeting more and more of that need through Power On. And I think I really appreciate you giving us a little picture of some of the additional benefits that would be, that are included in Power On that are beyond what a universal rate would offer. So I appreciate that. I think it's a really wonderful idea. As I understand it, the company has already agreed that that would be a great idea. And I again, want to kind of put that in context and speak to both of these requests and say that, I think the need is very much there, and many of our programs are not meeting as many people or not serving as many people as need that support. And so this would be a really slick way to greatly increase the reach of this program and provide those benefits. So I think that's my only question for you there, and thank you for proposing that.
Thank you, Chair Sieben. I have a question for the joint interveners regarding the randomized control study that they've asked us to order. And in particular, while they're getting situated, I read statute 216B.07, which, pretty kind of straightforwardly, and I think it prohibits what they're requesting, but I just want to give you the opportunity to convince me why I'm wrong.
Thank you, Chair and Commissioner Sullivan. So I think you're referring to the statute that says that there can't be unreasonable discrimination. And the way that we see it is kind of twofold. One is that no customer would be worse off under the randomized control trial that we propose, because the worst that would happen to them basically is the current Xcel policy for disconnection. Otherwise, the different methods that you'd be trying would be improving their situation, because we're trying to understand what are other ways you could address bill non-payment that aren't the current practice. I think, on the other hand, there would be customers who would be advantaged. So it's both disadvantaged and advantaged because they're not receiving the current disconnection practice. Maybe it's because there's a moratorium on some set of customers. Maybe it's because some other kind of different disconnection treatment is being applied. But in our opinion, that's reasonable. So it's unreasonably discriminated against. And we think it's reasonable because it's giving the Commission a chance to understand in a randomized way which of these approaches may better meet the goals that we're trying to achieve, primarily getting customers the ability to pay their bills and reducing bad debt and arrearages. So in that way, we don't view it as contrary to the statute, because even in the case where there is some differential treatment, it's reasonable, and it's the end result is a public interest goal, which is trying to improve disconnection policy and treatment of customers who aren't paying their bills.
Okay. You want to weigh in, Mr. Shardlow, or were you? Looked like you were like, you don't have to. But.
Madam Chair, Commissioner, I guess I'll just say I echo the motivation behind the proposal. I think some of the reporting requirements that ECC proposed in our rebuttal that are now being contemplated separately in 26.2 are not obviously the same level of protection as the joint interveners are proposing, but I think are trying to achieve the same sort of vetting of operating assumptions around the impact of disconnections.
Thanks.
I have a question for Xcel, and then I think a follow-up for Ms. McConnell. In the last rate case, the Commission made specific findings around energy justice tenants, and there was discussion in that rate case around how it's an important component of setting just and reasonable rates. And do you think that the ALJ in this record now picked up enough of that energy justice tenant description and continued that same framework of the overall consideration, which I think was the right one, that in setting just and reasonable rates, there are components of energy justice that come into the Commission's consideration?
Yeah, thank you, Madam Chair. I think that I do. I think I think at a high level, reading the ALJ report, like I said, in my opening, applied a very thorough analysis to this, and I think the ALJ's work obviously looked at the various the different laws that he's supposed to follow, but also the commission's the commission's previous decisions. I can't think of specific. I'm trying to search my mind on specific examples where those actual tenants came through, and I can't at the moment. But I don't think there's any question that the ALJ sort of applied those throughout the report, and also that the commission has over the past since our last rate case opened a variety of different matters and considered those through its different decisions. And I'm thinking of the low-income discount pilot that we've initiated, that it was very supportive of. Other matters in our service quality dockets. I mean, I think the commission has taken those issues very seriously, and they're reflected throughout the years and also in this report.
And Ms. McConnell, the same question to you. In the last rate cases, you acknowledged in your filing in this, or in your filings in this docket, you acknowledge that the commission did make specific findings around energy justice. And now if I can summarize or paraphrase for you, the joint interveners propose that we take it like a step further. And so can you just comment on whether the topic of energy justice overall and what specific actions you want the commission to take in this rate case on that topic?
Thank you, Chair Sieben. So we, as I said in my opening statement, very much appreciated the Commission's recognition in the last rate case of the energy justice tenants and their relevance. And I think that I wouldn't necessarily characterize us as trying to go a step further here. I think we're trying to continue a similar recognition in this case, and I think the ALJ report does that in a lot of respects. For example, he recommends undertaking a process to establish a definition for energy justice that the Commission would adopt that would provide clarity around what exactly we're talking about. Our primary position was to use the Institute for Energy Justice's definition because that's been well vetted. It's a established organization, but we'd also support a process to establish one here. So I think that's one example. The low-income rate process is another example, I think, that kind of continues focus on energy justice and equity that we would support. So I think there's a number of places where it shows up, and we are very pleased with that in the ALJ report and encourage the Commission to adopt those decision options.
Okay, thank you. Commissioner Hahn.
Thank you, Chair Sieben. So go back to the Commissioner Sullivan's question about randomized test issue. Academically, it's great. I think I understand academic aspiration of it. But have you thought about potential reaction from public? When we were implementing time of use, there was a huge concern by public about social engineering. Do you perceive that we randomly select people and telling them you are in the experiment? And do you think that will be well received by public or the ratepayers? One thing, if you don't do that, you may have to call everybody asking, do you want to participate? Are you expecting that will be also well received when you got a phone call from strangers saying that you will be in the experiment? I hope before you go further on this issue, please give more thought about how public is going to perceive in being this experiment. Goal is, I know, good thing, but also we have to worry about general public's perception on being in the experiment or in the social engineering study. And so far, we haven't received any good reaction from public. So I think that's my concern on this.
Ms. McConnell.
Thank you, Chair Sieben, Commissioner Hum. I do appreciate those concerns, and I understand where you're coming from. I think, our primary position is actually a moratorium on disconnections in light of the lack of evidence and the disparities that have been demonstrated. And from our perspective, that is a cleaner, clearer approach in order to develop the record around the efficacy of disconnection practices, whether they're really achieving what we kind of intuitively think they're achieving, or whether they're causing these harms without necessarily achieving those goals. So that's one reaction I had, is that that is our primary position. On the study itself, I do understand where you're coming from. We were trying to come up with a way to build a record around how this policy actually works, how other policies might work better. That was our best idea for how to do that, but I do understand what you're saying, that it especially if it could be challenging for the public to accept that. So I don't really have a reaction beyond that. I understand it's a balancing, and that there is that concern.
Commissioner Sullivan.
Thank you. Going back to the question around the definition of energy justice. Now, if the commission were to adopt that definition of energy justice, how would that be used in rate making? Because, I mean, we have definitions for rate making today. How would that be consistent with those definitions that we use today? Like when I think of equity in rate making, that's that everybody within that particular class is charged the same rate, and that the differences between, you know, cost to serve between large industrials, commercial, and residential, that's where you charge, or that's where people get different, that's where you discriminate. But how do you see the definition of energy justice as playing within our current statutory framework for rate making?
Ms. McConnell.
Thank you, Chair Sieben, Commissioner Sullivan. From our perspective, energy justice is a component of just and reasonable rate making and a consideration within the existing framework. And I think defining it helps make clear for everybody that we're all talking about the same thing, the same tenets. But I do think it plugs into the framework that we're familiar with and that the commissioners already apply in rate-making cases. It just makes clear that these tenets of distributive justice, restorative justice, the other tenets of energy justice are, among the others, factors in rate settings. Similar to, as you said, equity is also a component that has a long-standing place in commission regulation, and there is kind of a working definition that the commission uses for that. There is not one for energy justice. So I think being clear about what we all mean when we're talking about it helps in the application. Our expert, Dr. Chan, went through like all the cases filed and tallied up how many times people were referencing it, and I don't have the number off the top of my head, but it was a lot. But there's not a clear definition of what, are we all talking about the same thing when we're talking about it? So I think that clarity is valuable.
So here's where on page 13 of the briefing papers of volume 0, where we have this definition here at the bottom, joint interveners noted at least 235 filings, where equity refers to fair and just, but not necessarily equal. I know that the indication is that we've adopted that working definition of equity. But when we see equity refers to fair and just, but not necessarily equal, like that's where I get tripped up. Like when we're talking within a particular class of ratepayers, would that apply to that particular class of ratepayers? So without reference to cost?
Ms. McConnell.
Cost of service, I mean.
Chair Sieben, Commissioner Sullivan, I think it would. I think that comes up with the low income rate, the idea of equity, that there are some customers who do need ability to pay. You need some differential treatment to address the ability to pay of those customers. I think of that picture where you have people looking over the fence and some people need the higher box in order to look over the fence. Equality gives them all the same boost up, and equity gives them different boxes so they can all see over the top of the fence. So that's where I think that comes in, and it isn't necessarily a cost of service issue, but it does take into account equitable considerations and ability to pay.
I know that, I know exactly what you're referring to, the image that's in a lot of PowerPoints. I think a lot of people will struggle with that, like, why am I getting the higher rate within the residential class, but somebody else isn't, and here are the struggles in my life, and so. Anyways, thanks for this conversation. I do find it useful to me.
Mr. Dobson, or for the company, under Minnesota Rule 7820.1000, Xcel is allowed to disconnect customers if they don't pay their bill for the provision of utility service, as long as the company complies with notice requirements. The joint intervener suggests that the commission could order the company to suspend disconnections. It's really early in the day. I don't want to start talking about if the company would sue the commission. But what would happen if the commission adopted the joint intervener's recommendation that we order the company to suspend all disconnections?
Madam Chair, I guess the direct question that I would answer is, I honestly haven't thought about whether we would take some sort of legal action against the commission. I think the way I would answer that question, though, is, two ways. The first is, the commission already removed a waiver to that rule that we had that allowed us to do disconnections without a site visit. So I don't know if other people heard that.
It's not you. It's our.
Okay, that was.
It's the technology.
And so I think it has already taken an action to attempt to lower the disconnections that we have. I think that so we already have a process going on there. I think the other thing that I would say is we have had an increase in disconnections that has come sort of coming out of COVID, where we we eliminated disconnections for a period of time, and we were sort of slower than other utilities to ramp up, and so you saw arrearage balances growing, and that. Did my mic go out? Sorry. This is the most difficult answer I've given with tech. So that's caused disconnections to go up, and I know the commission is very we're very dedicated to removing to getting those back down. And so obviously you've taken an action with respect to that waiver. We've proposed RAMP here, which we think is another step, and we're very open to doing this. It's not good we don't like disconnecting customers. It's not something we want to do. Sometimes we think it's necessary, and there is a rule that allows us to do it. But we're very committed to trying to get those back down.
I appreciate that. And Ms. McConnell, I appreciate the suggestion that if we just suspended disconnections, that it would help people be able to afford their bills. But I think what we saw from COVID and having such a long suspension of a moratorium was that long term it can lead to bigger problems for the very people that we're trying to help. So while I appreciate the recommendation, personally, I don't think it's the way forward in this case or at this time. Commissioner Hom.
Thank you, Chair. Stephen, so this is a pure curiosity. So after there is a disconnection, they can call our CAO. We know what's happening at the CAO. Is there any other community action happening after this kind of disconnection happened by CAB agency or Energy Sense Coalition? Is there any action going on behind the scene?
Is that for Mr. Shardlow?
Anybody, if you have that program, let me know. I'm just checking whether anybody has that kind of program.
Madam Chair, Commissioner Hom, I will say that in terms of community action, once a disconnection notice is given, if they have received LIHEAP as a general grant, they then become eligible for crisis dollars, which are additional funding over and above the initial grant.
Yeah, thank you. Those are already protected. My concern is those are not protected. Let's say LIHEAP qualified, but not LIHEAP receiving, or because they are discouraged to apply, but the income level is a LIHEAP qualified people, but they got disconnection. Is there any CAP agency, any low-income help agency actively engaging in those populations?
Mr. Shardlow.
I don't, thank you, Madam Chair, Commissioner Hom. I don't believe that we are. I would have to defer to the company if there are any additional outreach from their customer care team.
Then, can I ask company? Yeah. Is there any your proactive action to tell that customer to reach out to CAB agency to find solution possibly out there?
Yeah, Madam Chair, Commissioner Hom, if I'm understanding the question right, I think within our customer care unit, I don't know the specifics of sort of how they do this, but my understanding is that yes, we work to try to put these customers in connection with the various sources of assistance that they can get, because again, it's our goal that they get caught up, are able to pay their bills and not get disconnected.
Do you have any statistics on those to show that whether that is an effective way to get them back on versus still they cannot get back on?
I'm not aware of those. We may, but I can try to find out.
Okay, thank you.
Commissioner Partridge.
Thank you, Chair Sieben. I just following up on that, I have a couple things I wanted to mention. One is, as we discussed, or I discussed with Mr. Shardlow, his proposal here to expand auto enrollment to all LIHEAP eligible customers would get those customers into Power On, which does provide support for paying down arrears over time with a payment plan that is designed to fit the needs of that customer. And so I do think that if we do adopt that recommendation, we will be providing support to more customers to avoid disconnection. And I think that will be on a very sizable scale if the auto enrollment is done appropriately. And the other piece that I wanted to mention is that, and Ms. McConnell, I think this is kind of my thinking on this proposal as well, that what we saw during COVID is that just putting in place a moratorium on disconnections allowed for customers to prioritize other bills, and therefore those arrears continued to grow and grow, and there was no funding to just wipe that out for them. And so they re-entered this new normal where disconnections can occur with huge balances that some customers have still been unable to pay down. And unintentionally, in having that disconnection moratorium, we were not pushing customers towards Power On and towards payment plans where they could get support for buying down arrears and paying their bills. And so I think that since then, we have taken multiple steps in various dockets to make improvements to the payment plan process. And here we have what I think is a very meaningful improvement in enrollment for Power On that would provide additional benefits and support for paying down those arrears. And we haven't talked about RAMP yet, but just this one single proposal to do auto enrollment for all LIHEAP eligible. So that's all of the folks who are income qualified would automatically be enrolled in Power On. I think that is a more productive way to try to support customers to avoid disconnections than to put in place a moratorium. because we did see really negative impacts to those very customers who were not disconnected for the duration of the moratorium. So, you know, I know there are other community support. I think there are county crisis funds as well, and we could probably have a great planning meeting on all the different types of community funds that are available for folks who are facing disconnection. But I do think that just in the context of this regulatory framework, we've put in place a lot of good protections, and I do think that, you know, this little tiny recommendation for auto enrollment, which sounds very administrative, is actually a really impactful policy change.
Thank you, Commissioner Partridge. If there are no other questions on Volume 0, then are commissioners ready to move to Volume 1? Yes. And we'll begin. The first topic in Volume 1 is about the coal facilities, and starting with the OAG and XLI, I think, is my question. Xcel filed corrections or updated decision options a couple days ago, and in Volume 1, Decision Option 1004 is to reject Xcel Energy's proposed regulatory asset for Sherco 3 and King plants at this time. And that was a correction that made sense even before I saw that Xcel corrected this. And I just wanted to check with you, Mr. Schultz and Mr. Maratska, that you think adding the new language at this time is a good clarification for decision option 1004.
Thank you, Madam Chair. Yeah, we agree. We agree that that's a fine clarification. We thought that was sort of inherent, but
Yeah.
assumed, but no problem with that.
Mr. Maratska?
Madam Chair, Commissioners, if the Commission prefers for the customers to revisit this issue at the next time, which is how XLI reads this, is that the issue is going to be relitigated then and re-examined, then XLI will, of course, abide by the Commission's direction. But
So, Mr. Maratska, just to remind me, you don't want to accelerate the depreciation for Sherco 3 or King, and and you don't want to ever create a regulatory asset. Is that your comprehensive position on coal plants?
the Madam Chair, Commissioners, the comprehensive position on the coal assets is that we may be able to discuss the appropriate rate recovery for certain aspects of this, but if the implication is that there's going to be a rate of return on an asset that has
Can you speak into your mic?
Sorry, to the extent that the Commission is directing that there may be a rate of return on that cost recovery post-retirement, XLI would oppose that as inconsistent with other decisions the Commission has taken.
And Mr. Schultz, overall on coal plants, your preferred decision options on all of these align with the ALJ report. Is that accurate?
I believe that's right, Madam Chair. I'm just double checking. But yes, that's my recollection. We are aligned with the ALJ.
And then, sorry, I'm jumping all over the place here, but for the other corrections that were made around coal plant expenses that Xcel filed, like in 1005, it's your decision option, but they were just clarifying that the numbers in here are stating, clarifying, I think, your intent. On all of the coal plant issues, you're comfortable with the revised decision options?
Madam Chair, there's not a 1005 here on Xcel's revised options. I think you might be referring to the Sherco 3 restoration costs not covered by insurance. Is that?
Oh, yeah, sorry, I'm jumping ahead. I'm jumping ahead, right?
That's a big
Just
difference
for
than
the
early
coal,
return.
right, sorry, just for the coal plants, then it's just 10:04. Yeah, and then 10:13 is on to the Riverside, so, okay. Wrong question. Commissioner Partridge.
Thank you, Chair Steben. Mr. Schultz, it would also be 10:02, right? So you'd keep the depreciation schedule as it currently is, and then for 10:04, we would reject the regulatory asset at this time. So it'd be both those, is that right? Just clarifying your position.
Madam Chair, Commissioner Partridge, that is right.
Okay, thank you.
Just to the department, I think what your concern is we could be backing ourselves into a regulatory asset. I think that's what you're kind of saying, is that if we push this off to the 4-tier analysis, we're going to get to the next rate case or at closure. Hopefully there's not a 202 order coming on that. We're kind of backing ourselves into a regulatory asset. Is that your concern?
Chair Steben, Commissioner Tuma, exactly. I think that is.
Can you state your name for the record?
Of course, Catherine Arnold, Assistant Attorney General for the Department of Commerce. That is one of the department's primary concerns, is that if we don't take this opportunity now to update all of the depreciation lives to match the authorized lives, this is sort of a one-shot opportunity to have those balance out in a net negative way. And if we don't take it here, just looking ahead at the schedule and the timelines, it's unlikely that there will be another opportunity, and it would likely be a regulatory asset situation.
In XLI, I think what you're saying, and Mr. Maraska, I have that same concern. What is that going to look like? And as I read the 4-tier test that we have established, I don't think we in any way indicate whether there is going to be a rate of return on that recovery of depreciation if we do a regulatory asset. That was, I think, what you just expressed a concern about, is if we get backed into regulatory asset, you're going to be paying a rate of return on a facility that's not used. But if I read the 4-tier test, that's not predetermined. Is that the way you read the 4-tier test?
Madam Chair, Commissioner Tuma, I would certainly agree that XLI would have all the arguments at its disposal to oppose recovering a rate of return at a later date.
We don't know what we're going to do at that stage. We're going to have to see it, but I think to the company, you would agree with that assessment. That's a future assessment, whether you get a rate of return on that deferred asset or whatever we're going to call it at that stage under our 4-tier test. Would you agree with that?
Madam Chair, Eric Swanson from Winthrop and Weinstein on behalf of the company. We agree with that, Commissioner Tuma, and I mean, just to further clarify the company's position at this point, we think the only decision option you really have to adopt from our perspective is 1002. You don't need to say anything on what's next. We just added the clarifying language because we thought it was necessary that not be interpreted as forever foreclosing you from approving a regulatory asset. But those are discussions to happen at a later day when we have more information.
And I clarified with our staff, and it looks like your spreadsheet indicates this is already all baked in already in the regulatory test years that we're dealing with now, and as is the extending the lives of the nuclear plants. So it's kind of like this. We could flip it and do some sort of rate mitigation here. That's not the case. If we do some sort of early recovery, it's going to affect the numbers pretty substantially in this rate case. And that's the concern.
Madam Chair, Commissioner Tuma, that's correct.
Commissioner Sullivan.
Thank you, Chair Steben. I just want to I think it's just a clarifying question, but if we were to do 1002, keep depreciation for Sherco 3 and King plants as filed, so King is fully depreciated in 2028, correct?
Madam Chair, Commissioner Sullivan, that's correct. That's when it's closing. I'm 99% sure that the depreciable life matches the. Or wait, I'm sorry. What was the question? No. When it was closing, or when it was the?
The closing is different from the depreciated life.
Yes,
That's what's at issue here.
King is scheduled to close in 2028. Correct.
Scheduled to close in 2028, fully depreciated at the end of 2028.
No.
No, not under our current schedule.
Current schedule has it fully depreciated under, at what time?
37.
2037.
2037 is the current depreciable rate.
Got it. Okay. No, you were going to say, what was, sorry, I didn't.
No, just the department wants to accelerate the
Yep. Yeah. I just was kind of trying to
align it with 2020.
put it into my brain because I'm thinking about the 202C orders and stuff.
Yeah, I was panicking about those two.
But I think the ALJ to the department made like the kind of obvious conclusion that I understand that, but for the nuclear plants, it would help balance out the rate shock. But it still would, if we did accelerate the depreciation, it still would be a significant cost to ratepayers here, and the department acknowledges that. I think your overall framework, though, was helpful just to help us weigh the different benefits of doing that. Is that fair, Ms. Arnold?
Chair Sieben, I think, certainly the department recognizes that accelerating the depreciation has a substantial financial impact if it's looked at in isolation. And I think in addition to the concerns you just laid out, we would also point to the fact that if it goes to a regulatory asset and that the recovery is extended, I believe it was $63 million in additional shareholder profits that would be recovered over the extended schedule. So there's a number of financial concerns, and we understand it's a difficult decision, and there's reasonable positions can differ, but we think that this is ultimately the most beneficial and fair path.
Chair Sieben, Ms. Arnold, as I understand it, we're not sitting here now approving a rate of return on a regulatory asset, and we're not considering the regulatory asset today right now at all. And so I think it is not a foregone conclusion that there would be $63 million in shareholder profit associated with it based on our decision today if we keep the depreciation schedule. Is it? Mr. Maratska, isn't that what you just discussed with Commissioner Tuma?
Madam Chair, Commissioner Partridge, that's correct. XLI is not consenting to a rate of return on a regulatory asset at this time.
Great.
Ms. Arnold.
Chair Sieben, Commissioner Partridge, that is correct. That $63 million would be based on what ratepayers would end up paying if the regulatory asset were created and it was this same rate of return as rate base. So that is an important clarification.
Okay, just for the public to know, we're not doing that right now, and that isn't a decision we're making, because I don't want the public to think that we are approving $63 million in shareholder profits at this moment, because we're not doing that.
And
For the record.
the company proposed creating the regulatory asset at the conclusion of the lives of the coal facilities, though. So 2028 is not that far off, Mr. Swanson. I see you're nodding your head, but I think I'm supportive of like kicking that decision off on the actual creation of an asset and not, I don't think the commission should at this point determine that we're going to set up the regulatory asset. Sort of to Commissioner Partridge's point, we can decide that later. And why are you nodding in agreement?
Madam Chair, because I agree.
Did
You're not deciding that.
Oh.
You're not deciding that now.
You did propose we do it, though, at the end of their lives and wanted us to establish it now.
We did, Madam Chair, in testimony, but we're very comfortable. If you want to address the issue, we're very comfortable with our modified 1004.
Which would also follow the tiered framework that all the parties have sort of played along with of that's a good way to do this. So I think that works. Okay, the next topic in the volume 1. Are there questions on that? Commissioner Hom.
Thank you, Chair Sullivan. Sieben, sorry. Okay, so I have a question to the department on this issue. I pertain to the decision option 1007
And we're talking about prepaid pension and the
Yes.
accrued liabilities, right?
Yes.
Okay, thank you.
So that is a department's alternative and Excel's alternative. Is it correct?
Chair Sieben, Commissioners, that's true. The department did offer that as an alternative. That's not the department's preference. The department's legal position is
Yeah.
that
Yeah, I understand. So set aside your preference, set aside existing Excel claim balance. Purely this is about future. In the future, do you still want to use this as your alternative to track this amount if Xcel has to pay above and beyond their allowed contribution due to the federal requirements? Let's say 2030, they're underfunded, and then they put enough money they allowed in the rate case. Still, they are short. How do you want to treat that number?
Chair Sieben, Commissioner Hom, I don't think it'd be appropriate to speculate about the position the department might take in the future. Obviously, this is somewhat of a novel issue, and so we've laid out our primary position, which is our legal position, and we've given the department, or the commission, an alternative pathway if it chooses to take it that. I think if this issue continues to be raised in future rate cases, the department will continue to look at it, and every sort of position we think is justified by the law and the facts is on the table.
Okay, thank you. So what is your understanding regarding property tax in the Xcel's power plants? How they recover any property tax these days?
Are you talking about property taxes generally, or are you asking if there are property taxes associated with the pension asset?
No, not on this one, but power plant.
Yeah, my understanding is that's recovered as an O&M expense, and there's either some sort of tracker true-up to reconcile that to actuals.
So if you go in that direction with this kind of expense, it can happen due to outside Xcel control. Do you have any legal concern with it?
With a property tax tracker?
Similar to property tax tracker, how about this pension expense outside Xcel's control, which is a federal requirement, and then they have to contribute more than they are allowed in the rate case allowance? Do you have any legal concern? I understand your position, your preference, but do you have any legal concern with it?
Chair Sieben, Commissioner Hom, I'm hesitant to sort of weigh in on that. Have not thought about that. I know the commission has able counsel. It's not something we've considered. It's not something we've proposed, or it's been addressed in this record.
Okay, thank you. And then can I ask OAJ? Same question, since you guys didn't take a position on this one, but set aside whatever balance Xcel is claiming as of today. That's not an issue I'm asking. This is about the future. Going forward, if you're using more like a property tax recovery tracker like a system on this issue, do you see any legal concern?
Madam Chair, Commissioner Hom, I'm afraid I can't answer that off the cuff. I'm sorry.
Thank you. So can I ask both of you next week again?
Yeah, I'll think about it in the interim.
Okay, thank you.
I just wanted to say I like where you're going with that, because with this, as well as some of the other issues, I think the uncertainty that is created, I mean, I understand all of the points about, we want to make sure that they're driving a hard bargain and, that setting the budget, but there's just this uncertainty, and, we have to find, in my way, we have to find a way to crack the nut without having an over and under collection in a way that's fair. So I like where you're going with this. I just wanted to say that. So I hope you guys have a good answer for him next week.
On the issue of prepaid pension, the commission authorized the department to hire an expert to look at the topic. They didn't really totally address the source of the prepaid pension asset and whether it's shareholder funded or coming from some other source like ratepayers or market returns. So, and the court later in their ruling told us to look at that. And so Mr. Dornfeld helped me with that the department now is saying we should do what overall, and then how are we supposed to continue to justify that when your expert didn't put a lot of information into the record that I thought they were going to on this particular topic?
Yeah, I guess to start, Chair Sieben, I'd start by saying as we disagree with the framing that you've laid out, what the court directed the commission to do. I understand that's Xcel's framing, but that's dicta from the Minnesota Power case. The court's clear direction to the commission was to give due consideration to prepaid or to pension contributions as an asset of a capital nature. That doesn't dictate any particular outcome. It just means we can't categorically deny pension as a capital expense. And none of the options that have been laid out by the department do that. We're asking you to, we can see that it's an asset of capital nature. And the question is, what's the value of that capital asset? And what's the appropriate return that should be applied to that? So our primary position is that that Xcel's capital asset has very little value because it's a speculative future interest. And so when you apply any rate of return to a valueless asset, you get a pretty small return. That's our first position. That's our primary position. We think that's dictated by the law and the facts of this case, and that the commission would be sound in adopting it. If the commission doesn't do that, our alternative is to say, okay, we accept that Xcel has a $90 million asset if you're going to go down that route, but they're not entitled to a weighted average cost of capital return on it. And that's the alternative that our expert developed through testimony. We don't think that the commission has to do that. We think that that gives Xcel a larger return than to which they're entitled. But if you want to do something else, if you're not comfortable with what we think is a sound legal argument, you could do that. But we just fundamentally disagree with Xcel's framing that the court said you have to, that the only issue is whether the purported prepaid pension asset is funded by shareholders. That's dicta in the Minnesota Power opinion that doesn't deal with this utility or, frankly, this rate case.
So does the department have a position on whether the prepaid pension asset is 100% shareholder funded?
Chair Seaman, I don't think that's clear on this record at all.
It's not clear that you don't have a position, or what percentage is then? And that's what I thought we were asking you to help us grapple with, and I didn't see it, the help
Chair
that I'm
Seaman,
looking for.
Chair Seaman, I don't think that issue is clear in this record. I don't think that there's a clear, definitive answer to whether the prepaid pension asset is 100% shareholder funded.
They haven't proved their case, is what you're saying.
Yes.
And Xcel wants to jump in.
Thank you, Madam Chair. Yes. Their witness said, by funding NSPM's pension plan at amounts above its pension expense, creating the prepaid pension asset. That's their expert's words. I mean, we thought we were taking an issue off the table for you on this one because we had agreement. The asset exists. It's long-term in nature. It was created by the company, and it's equal to the amount of funding provided above the expense. That's what their expert said. They offered something that we didn't think was the right way to do it. We think it deserves a weighted average cost of capital, but they offered the long-term debt. We said, let's agree for this case and get rid of this issue. We thought we'd done that. I'm sad that we didn't.
And
did for debt, but
now you leave us to figure it out. Yeah.
But I think the struggle we have is the value of that asset and whether you funded it. I think that XLI's position is I don't think even contradicts the department's new lead part that is de minimis and they don't even own it. But your point, Mr. Maraska, is that there's no way that they can establish that this is ratepayer funding. That's what your expert was saying, is that it may be that fact that it is overfunded or funded beyond and there's an asset there, but there's no way they can show that actually is shareholders' money. And that's what I understood Xcel's position was.
Madam Chair, Commissioner Tuma, to be clear, as we noted in exceptions, that this particular case was not really Xli taking on the issue because Xli is still taking on the issue in the past case.
Yeah.
And so for the ALJ to have concluded that the company's entitled to some return is what we Xli filed exceptions on. And so this is sort of convoluted simply because we're on remand in another docket on the same issue as we're talking about in this particular case, which I think makes it difficult for us all to work through.
Got it.
Chair Stephen. Thank you, Chair Stephen. And I don't mean to just be argumentative, but Mr. Dornfeld, I actually am going to read from the Court of Appeals order, and it says, this is talking about the previous prepaid pension issue. It says, remand is not required because a threshold question before including the asset and rate base is the extent to which the asset is shareholder funded. And the ALJ made a finding supported by the record that Xcel failed to meet its burden to show that it was shareholder funded. So anyway, not just in the MP case, but the threshold question in the Xcel case is also whether it's shareholder or ratepayer funded. And so not to be argumentative, but that is what we requested the department help us get to the bottom of. And so I think for me personally, it's a little frustrating that we didn't get much record development on that. And so it feels like we're kind of in the same situation again, trying to figure this out.
Appreciate that perhaps the record didn't develop the way the commission would have liked it. We don't dictate to experts, what
Right.
what their analysis is going to find or the exact contours in their analysis that would be inappropriate. I appreciate that that's perhaps your interpretation, Commissioner Partridge, of the case. It's our position that in a legal decision, there's the holding, which is sort of the core crux of what's binding on the parties and is precedential going forward. And then there's stuff that's called dicta, which is the sort of kind of commentary context that the court includes in its order, but that's not binding. And our position is essentially the language you've laid out there is dicta. It's not binding on the parties. The court's core holding is that the commission must give due consideration to pension contributions as an asset of a capital nature. And we think both our primary position and our alternate position do that.
The next issue, if there are no other questions, is Riverside Generating Unit. Commissioner Tuma.
I thought I saw steam coming from the plant the other day. Maybe I was delusional. Is it running yet, or what's the situation?
Madam Chair,
Mr. Swanson.
Commissioner Tuma, I'm not sure what steam you saw, but no, the plant is not operational.
Apparently it was my frustration.
I thought it was May 31st in the record. It said
That's what he said. That's what it seemed to be changing. So that's why I wanted to see if it does. And apparently it isn't any indication on when it will be.
Madam Chair, Commissioner Tuma, I think briefing papers noted that the company filed an update in February of this year in the FCA docket that indicated it was covered by a trade secret designation, but indicated that the date that is currently in the record is not correct.
I'll ask no more.
And any questions on the O&M expenses or the capacity revenues or further process on it? Commissioner Sullivan.
I mean, I think that is a fairly interesting idea that there's still, and I want to hear from the company, or maybe one of the opponents on it, is that the revenue came in for the entire year, 2025 and 2026 from MISO capacity auctions. And therefore, even though the plant was not operating, still isn't operating, it still generated revenue, and therefore, from your perspective, is still used and useful, even though had MISO called an emergency, couldn't have been there.
Mr.
Kind of like
Smith.
through the looking hole a little bit. Isn't that a little weird?
Madam Chair, Commissioner Sullivan, maybe I don't want to go through the looking glass, but the company's primary position has been and continues to be that because it was generating revenues, it was providing benefits to customers.
I don't know if it was the OAG that weighed in, or was it Mr. Dornfeld in the department?
Mr. Dornfeld.
Chair Sieben, Commissioner Sullivan. Our position is that, and the ALJ does a nice job of laying this out, the used and useful test has two parts. It needs to be in service and, I believe, trying to make sure I get this right, and reasonably necessary to the efficient and reliable provision of utility service. It's not whether generated some sort of secondary
Is
revenues.
utility service, though, could that be classified as revenues from a capacity auction?
Chair Sieben, Commissioner Sullivan, I think you'd be stretching the meaning of utility service, and it's not defined that way, and I don't think it's been treated that way in any previous cases. It's not treated that way in statute. It's not the department's position. It's not what the ALJ found here. So we just fundamentally, under existing case law, it's not appropriate to permit a return on a plant that was not used and useful during the test year.
Can someone remind me what the department is asking that we now send the case or make a new case about the cost for Riverside and send it to the CAH? And I don't remember what did the ALJ say? Oh, the ALJ said send it, keep it, get comments on it, and then maybe evaluate the prudency of costs and then maybe figure out what to do. So is that right? Or what, next steps and process from the department, what is your preference?
Chair Sieben, our recommendation, we proposed a new decision option or revised decision option on our June 5th letter, which was for the commission to make a decision now that there should be a contested case referral 90 days following Riverside's return to service. And the focus of that contested case would be to determine whether the outage was caused by Xcel's imprudence. And if so, then ratepayers should be refunded any rate replacement power that the utility incurred during the outage. We agree that it would be premature at this point to order up the rate case, or excuse me, the contested case, until after sort of the plant comes back to service, when the whole record of sort of the life of the outage and the causes of the outage can be ascertained. Right now, it would be sort of like trying to ascertain the cause of death while, a patient is still sort of in the hospital.
And Xcel, what's your position on next steps?
Madam Chair, Commissioners, if the Commission is pursuing this further, frankly, having just come out of a contested case hearing on similar issues, we're not excited.
The nuclear plant, you mean?
We're
being
not.
Offline?
Pardon me?
The nuclear plant being offline, is that what you're referencing?
Yeah, having just come out of that, we're not excited to immediately be tossed to the Court of Administrative Hearings again. We'd prefer that this play out through comments in the FCA docket, and then the Commission can make a decision, but to decide today that we need to litigate seems premature, frankly.
Could I just ask one quick follow-up? And then, Mr. Dornfeld, I'm just curious about, those revenues, from the capacity auction, $26 million, those do get imputed back, though, to ratepayers, right? So there is even though the facility is not used and useful, it did earn revenues, and that did come back to the benefit through the fuel clause, I would imagine. So I know you just said before, case law and all of what you said, but what's your position on that? Like, how do we get to take advantage of the benefit that it brought to us, but not have to deal with the cost?
Mr. Dornfeld.
Well, I think that's part why we proposed the contested case, because there will be an opportunity for Xcel to demonstrate that its actions were prudent and recover, demonstrate that it is entitled to charge customers for the replacement power costs, which would then flow back to the company in a permanent way. And there'd be an opportunity to reevaluate, any sort of lost capacity revenues or capacity costs there as well. But we think for purposes of setting rates, here, the Senior Citizens Coalition case is pretty clear about when you're allowed to put something in rate base, and maybe that produces a harsh outcome, but it's warranted here, and the utilities receives an ROE and a rate of return to assume business risks, and sometimes those risks are realized, and that's just part of our regulatory construct.
Commissioner Hom.
Thank you, Chair Stephen. Once again, it's a technical MISO issue. So did Xcel try to replace this capacity at the MISO PRA requirements under the Module E?
Mr. Swanson.
Commissioner Hom, I don't know the answer to that. That was not asked at any point in the proceeding. Are you talking about for the 26-27 auction?
So this is on the catastrophic outage condition at the MISO, and so you are not required to replace it.
Correct.
But if you replace the capacity with a functional capacity, you are not losing future capacity accreditation. That's why I'm asking.
And thank you for that clarification, Madam Chair, Commissioner Hom. At the time that the record was built, those decisions hadn't been made yet, so I simply don't know the answer as I sit here today. We can certainly explore that.
Yeah, that decision has to be made some time ago, not during the rate case, right after that outage condition. So Xcel must have either yes or no, and if they say yes, whether Xcel used their capacity or they bought the capacity, whether that has any impact to the wholesale revenue.
I agree with you. There's an answer. I just don't know it today.
Okay. Okay. Also, does capacity...
Commissioner, I'm sorry. Can I just ask you, so I want to make sure I understand where you're going with this, is that if they went back to MISO for additional capacity, then that basically it's a double dip, right? But if they didn't go back to MISO, if they procured it on their own, then they're basically internalizing okay, we still have excess, we can still make good on this.
That's a regulatorily double dip too, because that additional capacity could have been revenue for the ratepayers. Mm-hmm. So either way, it's a double dipping.
Got it. Okay. Complicated.
We have a separate RTO team.
Madam Chair, Commissioner Hom, I will say I still don't have a 100% answer. I don't believe we replaced it, but we're going to confirm on that. But the other piece, of course, to know is that is an issue for future accreditation. It's not. I'm sure you know this, but I just want to highlight the point. It's not an issue that would have impacted the capacity in this case because it's a 3-year future.
I know, but it's partially impacted because we have a multi-year rate case.
Okay, we'll confirm.
And sorry, I'm a little slow, but on the decision options, Xcel, your position still is that we should approve the plant in rate base for the test year and 2026.
Madam Chair, that's correct.
And then you haven't conceded that we should take it out even for the time it's not used and useful then? What does or in 1011 mean? Decision option 1011. Oh no, that's what the ALJ and the department are saying, take it out for the period it's not used. And even though it's still not operating, you're still saying you should be able to keep it in rate base, correct?
Madam Chair, that's correct.
That's
And-
your position. And
and
then
just
on O&M, sorry, go ahead and then clarify on the O&M for me too, please.
I was just going to clarify on 1011, we acknowledge that if that's the direction the commission wants to go, May 30th, 2026 is no longer the correct date. So we would need to have some discussion. As I indicated, we'd said before in a trade secret filing that date had been pushed back. But if the commission is interested in removing it from rate base, 1011 still doesn't quite have what you would be intending to do. So I want to make that clear.
Yeah.
On O&M, our position is to allow the company to continue to recover. If you disagree with that, then we would support the ALJ's 1014.
And that's to create a regulatory asset just for the O&M at this time.
Madam Chair, that's correct,
And then-
subject to later process and determination.
And does that later process then include the costs associated for the, well, I guess, never mind, that's not a good question. And then for the capacity revenues, your position is what now?
If the plant continues in rate base, then the capacity revenues properly flow back to customers.
Okay, and then for the department, and your position is consistent with the ALJ's, and can you propose updated language then, since the plant is still offline for 1011, decision option 1011, or maybe you did? Or is there anything that you can still file to kind of reflect what's happening here?
I'm going to let Ms. Campbell answer this one.
Thank you. Welcome, Ms. Campbell. When you're ready, please state your name for the record.
Nancy Campbell for the Department of Commerce. Thank you, Chair Sieben, for that question. Yeah, as you know, we did it through May 1, 2025 through May 30th, 2026. If you want us to update it for what was in 2663, Xcel's fuel forecast, where the trade secret number is that what you're saying? You want us to update it to whatever the new date is? That decision option? Because we denied costs for that period, because that's what we knew based on the record, and we think that's probably the right answer. But if you want us to provide updated numbers for the new date based on 2663, we can do that.
I'm just getting turned around, so I'm looking for your overall recommendation on the treatment of Riverside. It's still not operational, so the dates, I was thinking, would need to be adjusted, but I guess what you're saying is do we need to adjust decision option 10 and 11 or 1011?
I really don't think so. I guess I like to be a rule follower. And based on the record that we had when it closed, those were the dates that we had. And that's what the department did their adjustment on. If the commission decides they want to change that, we could do that, and we could provide that in a compliance filing for you if you wanted to do that.
Okay.
But
I
we're
get
sticking.
that.
But just to be clear, we're doing this exactly the way we did Sherco 3, which was not that long ago. We're kicking out all the costs in the rate case except for property taxes and depreciation, like we did in Sherco. And we're asking for a contested case to review the fuel costs and the capacity costs, so we don't have to have those discussions now. we can talk about those in the contested case.
That-
And we ask for an expert to help us with that.
Yeah, that's helpful. My question is just, then do we need to decide now to kick it to a contested case, or couldn't we wait until either the fuel clause filing or the FCA, and then decide to send it to contested case to try to avoid the expense of contested case, if we can just keep moving ahead
Sure.
with notice and comment, or do you have a strong preference?
So we offered this decision option 117A in our letter, the June 5th letter, and it says within 90 days of Riverside's return to service, refer the Riverside outage matter to the Court of Administrative Hearings for a contested case hearing to evaluate. And then we say whether Xcel's actions were prudent, talk about the replacement power costs, talk about the capacity costs, and to give us, we didn't say give us an expert, but we would appreciate getting an expert to help us with that. So I think that we don't have to fight about all this. We're kind of agreeing with Xcel. We can do it 90 days after it returns into service.
Okay, that's helpful. Commissioner Hom.
Thank you, Chair Stephen. So capacity doesn't matter unless there is energy. So I think we have to go into energy even though it's outside the rate case. So in my view, if we want to discuss about replacement energy, we have to give a credit to the capacity, right? So if we deny capacity value in the rate base, there is no such a thing as a replacement energy. So I think we have to pick and choose. We can do double dipping either on our side if we want to discuss about replacement energy or foregone energy revenue. Ratepayer has to own the right to use that capacity, right? But if we kick it out from the rate base, we don't have any right to that energy associated with it. So what is the department's position? I know this is an outside rate case, but what is the department position on the energy side of it in your AAA?
On the energy or capacity? Because you said
Energy in your AAA or the annual energy true-up. If you are pursuing replacement energy direction, we have to allow this as a capacity value. Without owning the capacity, how can you have a replacement energy discussion? So that's why I said, what is your path? Are you pushing for kicking it out from the capacity? Then I think we should drop the energy discussion in the AAA.
so in the AAA, we are challenging the energy recovery. Just a reminder for capacity, there's a rider that requires Xcel to pass through any revenues or any expenses. So respectfully, it's not really, to me, it's not really in base rates. It sort of is, but it's subject to a true-up. So I don't think that's an issue, and I think we can look at both the energy and capacity in the contested case, and that's what we're recommending in the FCA as well.
Yeah, but let's say if we don't own the capacity, how can we talk about energy produced by the capacity? That's why my idea is we cannot pursue both. We can pursue for the future capacity accreditation damage from it, but energy, if you want to pursue replacement energy cost in the energy, we have to allow this capacity as a ratepayer has a right to use capacity. If ratepayer doesn't have a right to use this capacity, how can we discuss the energy issue?
Respectfully, I think you're predetermining it, what's in the contested case. All you have to do is kick the energy issue and the capacity issue to the contested case, and we can all take a look at that and decide that.
Okay, thank you.
Are we done on this on Riverside, commissioners? Why don't we take a 10-minute break and we'll come back at 2 o'clock. The commission stands in recess. Okay. We'll come back from our recess, and now we're on approximately page 40 of the decision of the briefing papers in volume 1, and it's 2:00. And I'm
500 pages of
and as Commissioner Tuma said, we're not yet cooking with gas here, so we need to like maybe step it up a little bit, commissioners. That was not my suggestion, that was another commissioner's suggestion, so.
we won't blame you.
So who has questions on the next topic, which is Sherco 3 unit restoration costs? Right? No? Then the time of use rate implementation costs. Commissioner Hom.
Thank you. So Department and OAG on this issue, what is your concern with the taking Xcel's number?
Welcome. Please state your name for the record.
Good afternoon, Joey Cherney, Assistant Attorney General for the Residential Utilities Division. Could you clarify taking Xcel's number for?
So Department and then OAG asking denial of certain portion of their number, right? So what is the rationale?
Yeah, absolutely. So for the time of use costs, it's actually there are two buckets. There's the overall time of use implementation costs. That's the full $3.2 million, 2.8 Minnesota jurisdiction in capital costs. And then there's the subset of that, which is for the rate comparison tool. For all of the costs, we said that the costs weren't supported. This came in rebuttal testimony with just general categories and numbers on a page about, we're going to spend this, and we didn't really get an explanation of what are you spending it on, what is this based on, how did you calculate these numbers, anything like that. And then the part of it that we're more concerned about is the rate comparison tool costs, and that's the ALJ agreed with us on that portion of it. And for that, it's because this is a capital cost, has to be used and useful. We really don't know what this tool is still. It's apparently been in development since before the time of use rate was approved, but then also it was only beginning its design phase in October of 2025. And what Xcel said was, in response to us asking how, what is this going to look like? Do people have to put in their own information? We didn't really get an answer on that. What Xcel said was it could do all of these different things, but everything's also subject to change, and we don't know yet. And ultimately, by the end of the test year, they hadn't, by September of the test year, they hadn't started spending money on it.
Commissioner Hom.
Yeah. Thank you. Thank you. So your concern is input quality is not good, and then there is so much uncertainty in the output of it.
That's exactly right.
Thank you. And then is there anything different from department's position on this issue other than concern with the input that Xcel used to justify their number and then potential uncertainty with the output they will produce with this?
Mr. Dornfeld.
Chair Sieben, Commissioner Hom, the department did not really offer any testimony on this issue, and so we just defer to OAG and the Xcel on this issue.
Thank you.
Extreme heat, poor air quality reconnection and program costs. Discussion? Commissioner Sullivan?
Thank you, Chair Stephen. To the company, the decision option 1027 to give you the opportunity to do for us all to do more of a prudency review. Can you, on deferred accounting, can you weigh in a little bit on that?
Mr. Dobson?
Thank you, Madam Chair, Commissioner Sullivan. I mean, I think if it's hard to know what this is in context of. I mean, obviously our main proposal or our proposal is that we should get recovery of these costs. If at the end of the day what you would be saying is we don't want, we're not going to give you the recovery of these costs because of whatever reason, then we would oppose, or sorry, then that would be we would support that alternative. But the reason we opposed it was because we believe we should get recovery of the costs in general.
So I think it's the OIG that weighed in on this. Can you just speak a little bit more to the concerns? I mean, I feel like the company is doing what we requested of them, and this is the cost, but.
So it is doing what you requested of them, but they introduced this again in rebuttal with a page of testimony that said, we have this new program, and then...
Could you, sorry, I can't hear you very well. Sorry about that.
It said, we have this new program, that's all. And then they attached a schedule where there were some lines that said, construction work in progress, customer accounting, administrative in general. That's all the information that we got about this. Actually our motion for notice was the commission ordered them to file, okay, what were your costs for starting this up? So they said that construction work in progress would be $404,000 for the 2025 test year. Their actual costs were 1/6 of that, $63,000. So there's just, it looks like what they estimated was way too high. And we think that really deferred accounting should be in a separate docket. But just generally, this is a potentially larger expense that you ordered, so we'd be comfortable with deferred accounting on it. But we just want to make sure that they're not. We would be comfortable with deferred accounting. We just want to make sure that, so far the only cost information that we have here is that the costs are way lower than what they said.
Okay, thank you.
Now are we on energy supply and O&M next, or questions on that? Anything? Distribution, O&M, and vegetation management?
I guess I'd have a question on vegetation management. The company has routinely overshot on the budget. Feels to me like, the department has, I think it's a department, let me look at my notes here, that made a pretty good argument to put you in at, about 31 million or so. And even if you were to do that, that would be more spend than what what we were authorized last year. So I'd be interested in hearing your response on that.
You mean, sorry, just to be clear.
If you would even use the department's lower number, that's more than that's considerably more than your actuals last year.
Yeah, Madam Chair, Commissioner Sullivan, couple pieces to that I can go through. I think we in the last case you approved, more than we spent in veg management. I think there's a couple of things there. We had testimony sort of explaining sort of why that happened, and the budgets that needed to sort of shift around during the course of that MYRP. The other piece is our budget in this case did drop. So we, depending on which year you look at, 25 or 26, and which year you compare them to, our initial request was about $6 to $9 million below what you had approved in the last case. So I think we've accounted for a chunk of that. But getting to sort of the over recovery, or not the over, but the budget issue for 25. One of the sort of changes that we made in 25 was to, we developed the O&M budget for maintenance, and then we really worked to align some of our capital work with our O&M sort of veg management work. Meaning, when we are rebuilding a line, when we are adding, work to that, we go in and do veg management. And so we're coordinating that work better. We also had a lot of, distribution capital work in 25. And so we were able to actually get back, to the clearance schedule that we've wanted to be on. I know that's important because we want to keep these lines cleared. But what it meant is some of that veg O&M was lower than we would anticipate. We think we'll probably, like our O&M actuals actually kind of hit the department's number. But I say that all because I think I don't think that means our this is a reasonable test year, or sorry, this is a representative test year. We think these are reasonable costs, and when you look at our overall O&M budget for distribution, it's we were requesting about a 2% increase. Over.
Commissioner Sullivan.
I'd like to hear from Mr. Dornfeld.
Chair Sieben, Commissioner Sullivan, I think that Mr. Dobson has kind of hit the nail on the head. That the department's number is what they spent. So it's representative of the test year, and it should be adopted. This argument that Xcel is making is that the distribution management budget might be wrong, but it's okay because our overall fits like our overall distribution. It's consistent with our overall distribution budget. Just suggests that they are not doing a very good job of forecasting all of the subcomponents of the distribution management budget. Being wrong twice doesn't make you right overall, and I think that's our problem with their position. And as you point out, we've still recommended a number that's gives them an increase over their actual spending. It's just not excessive, and I think that's why we think our position is reasonable.
Good.
Sorry, Commissioner Sullivan, but just to clarify, and your recommendation is what the ALJ adopted, right?
Yeah, my
Mr.
recommendation
Dornfeld?
would be the ALJ findings 4, 6, 6, 6, 7, 6, 8, 6, 9, 70, and 71, and then decision option 1031. That's where my head is at right now. Which I think that's the department's.
Great. And then on transmission O&M, did we already cover that or no? Commissioner Hom.
Thank you. Chair Sieben, it's a quick question. Does this transmission O&M include the O&M for MVP lines?
Madam Chair,
Mr.
Commissioner
Dobson.
Hom, I believe it does, but I will confirm that in
Thank
case
you.
that's wrong.
That's it.
You will confirm and file tomorrow
Sure, that's fine. Yeah.
if it's a correction, right? Yeah, okay.
If it's correct, you don't have to do anything. Otherwise, you can file it.
Customer care O&M. This is XLI, I think, in your opening, Mr. Maratska, is this what you were getting at? That there were so many billing errors that you felt that all expenses should be removed from the test year in 2026? And I guess my question to that is, doesn't that make it worse in the future if you continue to eliminate the spending that's supposed to occur to help ensure that things are done correctly?
Madam Chair, Commissioner Tuma, the utility has an obligation.
Commissioner Sieben.
Sorry.
We look alike, but, I'm the one who asked it.
Weren't we talking about anvils last week? I think you just threw an anvil.
I think so. I think I'm thinking.
No.
Madam Chair, the utility's obligation to serve customers also includes an obligation to provide service and bill correctly. Mm-hmm. These are things that are obligations regardless of the cost. If the utility is spending money unwisely in its provision of service, then it should be disallowed. And the potential that that disallowance could make matters worse is even potentially more concerning than the failure to provide the service itself.
And did the department weigh in on this, Mr. Dornfeld? Sorry, I don't have it in my notes here. If it just says what on the briefing papers that Xcel and the ALJ recommend 1035 and XLI recommends removal of those expenses.
Chair Steven, the department did not recommend an adjustment here. I think the department generally is always concerned if customers are having billing problems, particularly of the magnitude that XLI is described in this case, but we haven't taken a position on the adjustment.
Commissioner Sullivan.
Thank you. I was curious, Mr. Moratzka, in your filings and in the briefing papers, it indicates that, I know that XLI wants disallowance of the entire budget, but you made the point of a 10 basis point reduction to ROE, and I'm just curious how you developed that. I mean, it's 10 basis points based a little bit less than $10 million. It's a pretty significant hit. So I'm just kind of curious how you developed that number.
You're jumping ahead.
I know, but it's in the customer care thing, I think, isn't it?
Well,
I mean,
I'm just being a little bit sarcastic to say they are linked, though.
Yeah,
but
yeah.
your point is well made. Then, wouldn't it be a double hit here to Commissioner Sullivan's point, or you're recommending both, that we disallow all customer care costs and reduce the ROE as a result of the billing errors?
Madam Chair, that's correct. Commissioner Sullivan, that's correct.
How did you develop the 10 basis point number, though?
Madam Chair, that's in the testimony of Ms. Billy LeConte, who testified on rate of return and ROE issues.
Okay.
So she had developed that testimony, that 10 basis point adjustment, in addition to the risk adjustment that was 50 basis points, and then combined still fit within the range of her DCF analysis. So it is an adjustment, but it is not outside the analysis that's supported.
Okay.
So both, therefore, are reasonable from XLI's perspective.
So take a look at your ROE experts. Okay, I will do that. Thank you.
The next topic is the general allocator. Commissioner Hom.
Thank you. So what is the portion of this employee allocated to the non-regulatory side? Do you know that number? In terms of number and then dollar amount?
Madam Chair, Commissioner Hom, I don't have the percentage or dollar amount off the top of my head. I know that, well.
Yeah, one of the testimony I saw was that the compensation to one of your executive or the group of executive was less than 1% allocated to the non-reg. That's why I'm just wondering what's going on.
I'm sorry, can you repeat that question?
So one of the testimony, I don't remember exactly who said it, but the assignment of one of your executive or the group of executive salary was assigned to non-reg, which was less than 1%.
Okay, I apologize, I don't remember this piece of testimony, but we'll dig it up and I'll
Okay,
get to that.
so you don't know exactly how this general allocator was constructed then?
Well, sorry, I don't know how the general allocator was constructed. The argument that we are having in this case is whether you use the number of employees or the billing hours. I guess what I'm not understanding is the issue of this one executive that you're referring to.
No, I mean, that's why I saw that number. I was asking about these employees, how much you are assigning to non-regulatory side.
Okay. I will make sure I get that information for you.
Okay, thank you.
And the updated decision option, wait, was there an updated decision option on the allocator? No. 1039. Oh yeah, Xcel, your updated, is that what you were just asking, Commissioner Hom? Sorry,
It was a general allocator. I do not have any other question
or the
beyond
general
that.
allocator. Oh, okay, never mind. Then, any other questions on this? Then the next is indirect wildfire costs allocation. No? Base pay. The incentive compensation. Some of these were, the decision options were slightly modified in this section. I don't see anyone having a problem with the modifications that were, or the red lines that were made. The annual incentive plan costs, top 10 executive compensation.
It's a minor issue.
I have an idea of what I think, but I guess the question for the on executive compensation for the OAG or the department, the ALJ recommended we initiate another proceeding. It seems that we don't need to do that at this point to me. Do you agree with that? I guess regardless of what the commission decides to do on executive compensation?
Chair Steven, we disagreed with the ALJ's version, which was just generally looking at how do you do executive compensation. What we had proposed was a little bit different, which was opening a docket to talk about how could we tie recovery of executive compensation to essentially achievement of affordability metrics, on the idea that if there was this public evaluation of, you know, how our Xcel's ratepayers doing, that then Xcel could, if they achieve those, then they could recover some executive compensation, because there would be a demonstration that ratepayers' interests are actually being taken into account.
Which I understand. I understand your argument for doing that and establishing a PIM around that topic. It makes sense. But I guess my question is, you're comfortable that we could make a decision on executive compensation on the record we have now, though, as well?
Madam Chair, that's correct.
Okay. And you agree with that, Mr. Dornfeld?
Chair Steven, yes. I think there's a robust record here for the commission to make a decision.
Any other questions? Commissioner Sullivan?
Doesn't Xcel already don't the executives already get incentive compensation for conservation, for achieving conservation?
Madam Chair, Commissioner Sullivan, we part of our Xcel's long-term incentive is for the environmental impact, so a decline in carbon emissions.
But I mean,
regardless of how the state statute changes, they get that. Yes.
Yeah. Right. I'm just kind of thinking that if you've already receiving compensation based on it's already there for conservation. I mean, that's affordability.
Commissioner Partridge.
Commissioner Sullivan, my understanding is that conservation as a specific metric was removed from the calculation or the metrics that go into executive comp several years ago, and now it's greenhouse gas emissions reduction.
I confused two things. That's yes.
Okay.
Yeah.
Limited availability benefits.
Oh, which one?
Miscellaneous benefits and the other costs for life and long, I forgot what LTD is, expenses, questions, non-qualified expenses, questions, board of directors, outside services, organizational dues, employee awards, investor relations expenses, rate case expenses, one question on rate case expenses for the OAG. I know you cited that settlements where half of the costs of rate cases were removed from expenses, but this has been a pretty long litigated process so far. So what's the justification for reducing half of the expenses?
Madam Chair, thank you for the question. Our argument is that since shareholders clearly benefit from rate cases, they should help pay for the cost. That's it in a nutshell.
They should pay for half the cost.
Yes, because arguably also rate cases benefit ratepayers by putting the utility in a position to provide reliable service. It's not something that's been litigated in the past other than in these settled cases, so it's never come to you guys for a decision before, but we cited those as pretty limited precedent, but the commission determined the rates resulting from those settlements to be just and reasonable.
Liquidated damages, insurance. Insurance. Commissioner Duma.
So, parties, if you want to go to Miller rebuttal, Schedule 2.
We were cooking with gas.
Schedule 2. Schedule 2 at the
Schedule 2, yeah.
end.
At the end, say, yep.
This
I
can't
think
be
it's
handed
PDF.
out.
It's
can't.
trade secret, so
Can't be handed out.
I can. It can't be handed out to them, but you
Yeah,
all have it. I'm just
yeah.
trying to make it easy for you, so you don't have to go find Miller.
Wait,
There were like
just
50
a
of
second. So, we are, Commissioner Tuma just passed around just to commissioners the trade secret. Could you describe what it is and where in the record? Clearly, Commissioner Tuma, so.
That's where I was going. So it's a Miller rebuttal, PDF 23. It should be his Schedule 2, which is and I believe I can describe what it is, looking at Xcel. It's the historical insurance spend and forecast.
Correct.
And just a second, did parties who have trade secret access catch that and need any clarification on what Commissioner Tuma just said? Ms. Arnold?
Yes, that's Miller rebuttal, Schedule 2.
Schedule 2.
Thank you.
And it should be, like I said, it's the actual expense and forecast expense, historical.
Commissioner Hom?
Yeah, Commissioner Tuma, which number is a trade secret and which number is not?
This is listed as not public in entirety, so I guess my understanding is the descriptions of each of the insurance, that was my next set of questions, the descriptions, like of what kind of insurance, Acme Insurance or whatever, to Xcel, that is not trade secret because it's, Mr. Miller talks about it throughout his non-trade secret documents. Is that accurate?
Madam Chair, Commissioner Tuma, that's fair, yes.
The dollar amounts are, my understanding, Mr. Miller in his direct did make reference to the Neil insurance amounts, Neil surplus insurance amounts, but I don't think I need to mention the actual amounts, but he did make reference to them in his direct, so I'm guessing that's not trade secret, but like I said, I don't think I need to talk about the actual dollar amounts. I'm okay though referring to things generally, like it has fluctuated a lot, or it's flat across the column or rows. Is that a fair assessment?
Mr. Swanson.
Madam Chair, Commissioner Tuma, that causes no heartburn whatsoever. Yes.
Okay. And I'm looking at the department, and I obviously this was from last rate case. I asked for lots of information description. They provided me a good set of description on most of them. I still don't know what captive distribution is because I looked throughout the whole record and nowhere was it described to me. But here's my thinking, and I'll just cut to the chase. When I look at these numbers, your position is that there's so much fluctuation for your average, okay? And you make a recommendation of about $5 million in each year's, $5 million plus in each year, reduction based on historical. A lot of that probably is because excess liability insurance has exploded over this time, okay? And that's not here. We don't see that because this is historical. But when you look at the actual Mr. Miller's testimony about what should be covered, he has a significant increase in that category upward, okay? And so I'm struggling with how to do this because, as you know, last time there was lots of fluctuation. The one that caught my eye years ago, if you look down at the bottom, just above total, there is captive distribution. Still don't know what that is, okay? But you see that it has dollar amounts in essentially 5 of the 8 years. But when you look at Mr. Miller's testimony, what she covered, he has 0 in there. So in other words, every time there's a refund in that one, the ratepayers who paid for it don't get any of it back. It goes right into Xcel's pockets. Not a lot of money, I get that, but that's what got me bothered by this whole thing in the first place. How is this working? And I suggested that we talk about another mechanism. You said a symmetrical kind of look at this in the end to see if we could true it up total. I'm kind of going to blame Ms. Campbell because it sounded like her way of communicating when I read the record on this is that I don't like that, okay, because there's not an incentive for the utility then to go find appropriate insurance, okay? What I understand from reading your record, okay, if you draw a line, if you go on where it says the insurance O&M column there, if you draw a line under other insurance and above nuclear property insurance, okay, correct me if I'm wrong, okay, it seems like most of the, what I would call fluctuation, the volatility, I don't know what word you want to give it to it, occurs from that line down, dealing with mostly the nuclear things, again, not knowing what captive distribution, all the other ones are nuclear. And when I read the record, that's because it's not really insurance, it's more like they're working with other nuclear companies to cover liabilities. So it's almost like a joint powers liability, we're going to share the cost, which is similar to insurance, but really not insurance. And so if you have one big nuclear problem happen somewhere in the country, there's going to be a big spike. Where there's nothing happens, there's no spike. And that's where a lot of the volatility comes. Correct me if I'm wrong.
Ms. Arnold.
Chair Sieben, Commissioner Tuma, that is the department's understanding as well, as we put in, I believe, testimony and briefing that there seems to be certain categories that fluctuate very unpredictably and are very significant, whereas other categories are much more likely to be accurately forecasted.
And to the company, that's the way I'm reading this spreadsheet, or read the record, anything that I'm saying wrong, it seems like the volatility is happening in this essentially nuclear property, nuclear interruptible, nuclear liability, the NAREL refunds, both on costs and also on distribution refunds. Am I wrong in that assessment?
Madam Chair, Commissioner Tuma, I think that's probably a fair general assessment, yes.
So I think there's two courses here. I'll just really cut to the chase. One, we can just create a separate category for nuclear plus captive distribution, whatever that is, and true that up, okay? Or we can use the 5-year assessment, okay, and say that every refund under nuclear liability, ICRP, NAREL, and captive just gets refunded to ratepayers, probably using the DOE settlement refund that we have. I mean, to me, those are the two options that we have to accomplish what the ALJ suggested, which was a symmetrical true-up, but also to accomplish what you want, which I agree. I think the 4-year historical from other on up, okay, makes good sense, and I would agree with that, okay? So I guess I throw it to you. You don't have to make a decision now, but what I would like from you, if you could, okay, look at those two options, tell me whether you agree with it, and then give me the financials for it, because what it'll result in is an increase in the base rates, because you assume if we're going to do a refund, you're going to have to take the refund out of the base rates. It's going to increase the base rates. And so that's what I anticipate would happen. But I guess I want to know from you if you can put that together for me by next week, and I will put a decision option together for tomorrow that does one of both of those, okay?
Ms. Arnold.
Chair Sieben, Commissioner Tuma, I think we all know I would not be the person putting the numbers together, so I would defer to Ms. Campbell for an answer on that.
Chair Tuma, could you just give, or
I'm still the little guy at the far end, yeah.
can you give us exactly which years you want that information for? Are you looking at for 21 through 24?
What I'm looking from you is you did a 4-year look back, okay?
Yep.
I want you to continue to do, so option one, continue to do a 4-year look back for other on up, okay?
Yep.
And then a 4-year look back for all the nuclear with a refund of all those refunds that you see under the nuclear section. That's option one. Option two, okay, is to do a 4-year look back on everything, okay, and then do a refund or true up just on the nuclear stuff. I don't know, I'm probably confusing you, but so I'm looking at nuclear on down to do a true up. That's option one. And then do a 4-year look back for the other insurance on up, okay? The other choice would be to do a 4-year look back with a refund of everything to ratepayers. In other words, there's no true up. It just, you tell us what you think it should be under the nuclear, and they get any refunds come back to ratepayers. So that's what I see as the course of action. They suggest is 2 years, and we can have that debate when we get to it. But yes, Mr. Swanson.
We will take our best stab at doing that.
Thanks.
Madam Chair, Commissioner Tuma, the most significant concern that we have about that proposal, and we'll need to see it fleshed out a little bit more, but the 4-year look back, if it applies to everything, for example, other insurance and above, that's including excess liability insurance. If you look at on Schedule 2 of Mr. Miller's rebuttal, the 2021, 2, 3, 4 numbers, and then look at his Table 1 in his rebuttal, right, on page 3, a 4-year look back doesn't even come close.
And that will be the debate we will have when we get back here next week.
Can't wait.
I just want to know what that would
Sure.
look like. We can still do a 2-year and also talk about your approach where you have your experts look that out. So my understanding right now, it'll be a little different numbering than the $5 million difference, and so I just want to flesh that out first.
Understood.
And you'll
Thank you.
see that, and you can make your arguments, but I just want to get a decision option together that looks at either a true-up or a full refund in the nuclear area only, and trying to separate that out. In the insurance debate, it'll be a separate debate.
Madam Chair, Commissioner Tuma, thank you for the clarification.
Commissioner Sullivan.
You've got me totally confused,
That's
Commissioner
good.
Tuma.
That's my goal.
When I looked at this, and my thoughts were more high level, but I looked at costs that, you have basically, effectively from an insurer's perspective, a total seller's market. They dictate terms. The historical approach the old approach where Xcel was forecasting didn't work because they were overshooting. The approach that we tried the last go round, where we did the 4-year look back historical approach, we missed pretty significantly on the underside, like $25 million underside. The old approach, they were over about $4 million. And from my perspective, I looked at this and I said, the most straightforward way to address this going forward, and I know that I heard you say it, and I know the department's not going to like this, but have a true up. And, or give Xcel their number and then just let them be within that number, and that's the number. But I kind of felt like with the nuclear credits, very similar like on prepaid pension, like let's get to the actual brass tacks here and let's have a true up. And I know that gives Xcel not as much, that doesn't put the fire under them to negotiate as hard, or at least I hope that that's just academic, but that's my concern. But I get it. But like at the end of the day, the practical problem can be solved with just a straightforward true up across the board. And that's why like the nuclear credits will get trued up if they exist or not. And that's where I was at, or where I am at. Like, it's simple.
And I would encourage you to look closely at Miller's direct. He talks about the nuclear, and when you read that, you'll find that it really isn't insurance, and it really should be. That's what I'm trying to say is one of the options we should have is let's just take the nuke out. That's causing the problem. That should be trued up or refunded in a way that treats the ratepayers whole. But the other insurance is truly classic insurance, and that will be in front of us, that discussion about, what is the classic insurance? Should it be the 2 years? Should it be their assessment? Should it be the 4-year? We can have that conversation separately, but I'm trying to give an option to just take the nuke out and separate it and let that be trued up somehow or refunded somehow, so ratepayers are not in a difficult position, or Xcel in this situation has been a difficult position because it has caused such fluctuations that it really isn't, to me, insurance. And so I'm trying to separate it out so that we can get Xcel an opportunity to make a fair rate of return and build an appropriate base case. But these nuclear plants are a little different animal, and that's what I'm trying to separate out. And so we'll have that conversation. I just wanted to get the numbers out there so that you could see it, and that you could see where I was drawing that line on this spreadsheet. And I think it'll become clear when you read that. Certainly, we could do it that way. We're just a straight up true up like the ALJ recommended. We could do it that way, and I would agree with you. I would rather have that than what we've had in the past. So I'm actually in agreement with you, but I was trying to narrow it down maybe to accomplish some of the discipline that the department was looking for.
So, sorry to cut you off, but basically, like, you're like, okay, I want to put a toe in the water and see if this idea works, but if not,
Yep.
Okay, I got it.
I'm not locked in stone on this.
Okay, got it.
Thank you, Chair Steven. So my question is a lot simpler. Why this total number is a trade secret?
Madam Chair, Commissioner, we could perhaps revisit whether the total number needs to be. It is very important that by category the numbers stay trade secret.
I understand that, but why total is? And the second, why there's a forecast is there without the regulatory adjustment. I think the only thing we care is how much we are paying, right? How much ratepayers are paying. This is your internal forecasting. Where is your comparison of this number with the actual rate case allowed amount we are comparing with? To me, comparing these two numbers is not relevant to me. It's your problem. My problem is when we are comparing your actual with what rate case allowed spending amount, that does matter.
And Madam Chair, Commissioner Hom, that was in Table 2 of Mr. Miller's rebuttal testimony, page 8.
So there is other table.
That
Okay,
is.
thank you.
Yeah, there are more tables. I just wanted to get the one that has historical. So sorry. And I think, if I remember right, I think in his direct, the totals were not trade secret. So I mean, I think it was just a.
Madam Chair, Commissioner Tuma, I don't recall, but we'll check on that.
That's my vague recollection. I kept ever coming back from Mark and reading it. So.
Property taxes. Distribution capacity investments. And targeted undergrounding.
Targeted undergrounding.
Commissioner Sullivan.
What's my place here?
I don't know why you only have like 500 pages in front of you.
What's your
I
problem?
have not lost my place yet. Just kidding.
I think I'll be okay. I don't need to ask anything out. I'll be fine.
Virtual power plants. Equity considerations in distribution planning. And classification of AMI meters and equipment.
Yes.
Commissioner Sullivan.
I want to ask the company, I'm giving you the chance to talk me out of why Mr. Barlow.
Oh.
Mr. Barlow, welcome. Please state your name for the record.
Thank you, Chair, Commissioners. Ryan Barlow from Cozen O'Connor on behalf of Xcel Energy.
Mr. Barlow, when I look at this, if the 1/3, 1/3, 1/3 approach, you have the 1/3 demand, 1/3 energy, 1/3 customer accounts. So the company wants all of it to be run through the customer accounts along with XLI. But I look at all of the programs that are available via our new meter system, which is a very capable meter system. And, we have TOU rates, we have EV programs, we're having, a number of different things. And to me, it seems like this is much more than just customer counts. There are significant system-wide benefits. So why am I wrong?
Thank you, Chair, Commissioner Sullivan. I first want to say that this issue on the briefing papers is a little complicated because it's covered in both Volume 1 and Volume 5.
I can't hear you very well, sorry. Yeah, okay.
Is this better?
Yeah.
There are decision options on this issue both in Volume 1 and in Volume 5, so it's a little confusing. But I first want to clarify that we're comfortable with the department's recommendation to go do a study on this and update it for the next case.
Yeah, I think that's good.
That's our preference here, and our primary request is that you give us a chance to do that study, get the information, and bring it back to you before making a decision that could really significantly change costs, both in this case and in the TCR rider. We don't think that the 1/3, 1/3, 1/3 makes sense. The ALJ found that it's arbitrary. It's not based on any real numbers.
Didn't the ALJ find that they were all kind of arbitrary, though? And that this was the best, least arbitrary thing?
Thank you, Chair Commissioner Sullivan. I don't think that he found they're all arbitrary, but I don't dispute he thought this one was the least bad of several bad outcomes. Our proposal would be, let us go find a good outcome and not jump to a conclusion before we've done the analysis. We also do think that there's a record here showing that these costs aren't 1/3 energy related and 1/3 demand related. And this gets very technical, and when you classify something, the reason you're doing that is to get to the allocation. And a demand allocation would spread the cost to customers based on how much demand they're using at different times of the year. A meter costs the same no matter how much the customer using that meter consumes across the year. And that's the same for energy. The meter costs exactly the same no matter how much energy that customer is consuming across the year. And this change is potentially quite significant, and we want to make sure there's a factual basis for moving that many dollars around. And I think the final point that I would make, Commissioner, is that this is a change for the next rate case. It's not going to change the revenue apportionment decisions you make in this case. We're not going to be able to rerun a cost of service over the weekend. It could change which methods you prefer, but you don't need to make the decision now in order to make a decision in this case. And I think that there's good basis to let us go do some analysis and come back with a better developed record for the next case.
How much money does it shift by moving, just keeping it in the, as the customer count? How much money does it shift if you go 1/3, 1/3, 1/3? Like, what are we talking about? I know it's in the record. I'm not recollecting it.
Thank you, Chair Commissioner Sullivan. One complication is that in this rate case, almost nothing, because there are almost no AMI dollars in this rate case. They're currently being recovered in the TCR. The ALJ's language is a little bit unclear, but it can be read as telling us to go change the TCR allocations, and there it would be quite significant. The metering rate base is $300 million right now.
30 million?
$300 million.
300, okay.
I don't have a revenue requirement number, but that's something we could get and provide to you if you would like it. I'm sorry, Chair, I could not hear you.
I would just like to, Mr. Schultz, I'd be interested in hearing your thoughts.
Madam Chair, Commissioner Sullivan, thanks. Yeah, I think I don't disagree with much of what Mr. Barla said. There is very little AMI costs in this case. The decision, as the ALJ recommended it, is to apply this classification through the end of final rates in the next, or until final rates are established in the next rate case. And the TCR rider costs, the AMI costs in the rider, Xcel expects to move in and propose to include in base rates in the next case. So there's not a big cost. There's not really an impact on this case. But we do disagree with the idea that you just need to look at the cost and how the cost compares to old meters, and that'll tell you. That's not going to tell you, how much demand or energy benefits these meters have. If you're really allocating according to the benefits, the study that's being contemplated is not going to give you that full information. It'll tell you, maybe, arguably, if you assume that the cost of old meters is purely customer related, which we don't necessarily agree with, then the incremental amount that smart meters add is some combination of demand and energy. That's all that study would tell you. We think that the analysis that would be required is more like what Xcel did when it sort of brought forward its AMI investments to justify. And then in that filing, I believe they did sort of say, here's the kind of benefits these meters would enable. And you could look at those different categories, and then you could sort of look at each category of benefit and say, okay, this is demand related, this is energy related. But so we're not opposed to the study either.
Isn't anything above, like, base level, like the way I think about this, is anything above like a base level, just like a turtle meter, is going to go into, demand or energy? Because it's doing more, it's better, like, as opposed to just customer count. Do you know what I'm saying?
Madam Chair, Commissioner Sullivan, yes, I mean, I think that is logical to me. I guess the question we are still investigating is any of that, even the pre-existing meter cost, we're not sure it's all needs to be purely customer related. I think that's a question for the future, but yes, I agree with you. The incremental amount
Kind of almost
surely
like the minimum
seems,
system.
yeah, the incremental amount surely seems to not be customer related.
And also, like, it feels to me like as the, advanced meters are more fully utilized, this is going to shift over time. This is going to, if you truly had, full virtual power plants and everything is kind of running at full tilt, this is going to allocate much differently between, over time.
Madam Chair, Commissioner Sullivan, yeah, I would agree with that.
So that, I think, probably argues for doing that study that Mr. Barlow indicated.
Yeah, Madam Chair, Commissioner Sullivan, yes, but again, the study that's, as it's outlined, and as I understand it, it's not our recommendation, but it's just, I saw it phrased in the briefing, in the decision options as comparing the cost of AMI meters to old meters.
Mm-hmm.
It seemed pretty simplistic to us, but.
Mr. Moratzka, okay. Mr. Moratzka, in the TCR, what do you see as the moving away from the third to just a pure customer count? What's the benefit to your clients?
Madam Chair, Commissioner Sullivan, it's a matter of reflecting cost causation. I agree with Mr. Barlow's commentary that by purchasing a meter, AMI, once it's purchased, that cost doesn't vary based on the amount of energy consumed. That cost doesn't vary based on the demand on the system. It's a fixed cost.
But I mean, it would shift tens of millions of dollars away from your clients, though, correct?
Madam Chair, Commissioner Sullivan, I don't think there's necessarily record development in this proceeding on the actual revenue that's shifted. What it does do is acknowledge cost causation for purposes of the class cost of service study, which is the starting point for how the commission is setting rates.
In the rider, is it now, in the rider, is it recovered via energy use? Is that what the rider?
Customer count. Or no, it's one-third.
Or is it one-third? I was trying to wonder, what is the rider recovery now where it sits before we get to the rate case?
Thank you, Chair Commissioner Tuma. I might need to check on that, but my understanding right now is that it has been historically customer allocated, but there's a different weighted allocator being used in the TCR right now.
Oh, Mr. Schultz knows.
I believe the commission recently took up, so it sounds like they're using the P60 composite distribution allocator according to my analyst, so that I think that includes demand and customer.
Okay.
I remember it.
I thought we did a third back in the day. This, and I think.
We did that for Minnesota Power.
Oh, okay. Got all this stuff floating around the old Duder's head, man.
Okay, moving on to the resolved financial issues. Commissioner Hom.
Thank you, Chair Sieben. So it is about TCR rider. So Xcel, can you prepare your witness who can actually factually testify on how you implement MVP, LRTP in the TCR rider? I'll ask the department first while you guys are preparing the witness.
You'll ask next week or now?
No, today.
Oh, okay.
Yeah, because it'll have a huge impact to all other my decision process.
Do you know who are you asking for?
They're looking back in confusion, so they
I don't think they know.
They may need somebody outside the witness. Or if anybody can answer, that's okay. So my question is, how you treat MVP and LRTP transmission line in your TCL rider, And then there is a testimony saying that you never rate-based MVP lines, and 26 and 26A schedule in MISO charges are permanently in the TCR riders along the line. So for the department, is it your understanding that Xcel never rate-based MVP line in their rate case?
I believe for MVP lines like Brookings, they started in the rider and they did roll into the rate case.
But yeah, but I don't know, I may misunderstood, but the testimony says 26 and 26A is in the TCR, and they didn't rate base it. So it's a different way of rate basing it, because Xcel, I'll confirm whether they're using all-in approach versus an all-out approach like Minnesota Power and Otter Tail. If they confirm it's all-in approach, doesn't matter, right?
Yeah, so my understanding, and Xcel can confirm this, is they use the all-in approach, but they use the lower Minnesota ROE. So they're not giving us the MISO ROE.
That's
The revenues. That's the difference between what Xcel, MP, and Otter Tail are doing.
No, that's why I want to confirm that with Xcel, whether they are giving difference in ROE to the ratepayers or not. So that's the eventual question.
Hi, please state your name for the record.
Benjamin Halama for Xcel Energy. And so Nancy Campbell is
Can you
right.
speak up a little bit? It's not your fault, it's our technology, apologies.
Is that better?
Yeah.
Yep. Benjamin Halama for Xcel Energy. Nancy Campbell is correct. In the TCR rider, when a project is first created, and so obviously the MVP and MEP portfolio extend over a long period of time. And so all the projects start in the TCR rider, and then over the years we've rolled certain projects into base rates. And so, you specifically mentioned the LRTP portfolio. That's still in the TCR rider. The clarification around the MISO Rec B revenue and expenses, those are passed through, not in base rates, but those revenue and expenses from MISO are passed through the TCR rider, and it is reflected at the state authorized ROE of 9.25 currently, based on the decision in the last rate case.
So what you're saying is, because the Xcel ratepayers are paying for the MVP cost, and they should get all the revenue associated with it. So that's why you are rate basing some line at the Xcel Minnesota rates. What is the UR flow through to the Xcel ratepayers in that true-up account in the 26 and 26A?
Mr. Halama.
Thank you, Commission Chair and Commissioner Hum. Can you restate that question? I'm not following exactly what you're asking.
So, department witness said you are only giving back Minnesota ratepayers at the rate of Minnesota rate, not at the what you are collecting from MISO.
Correct. Ratepayers are paying for the rate-based cost of those assets using our state authorized ROE, and then we are returning the Rec B revenue credits and Rec B expense to the customers at the state authorized rate.
Okay, you are not flowing through 100%.
Correct.
So you are running non-REC operation at the MISO without commission approval.
That was an order point in the last case, and we are following the order point from the last rate case.
So last rate case, you are allowed to do that?
Yes, that was the order
not,
point.
Not the MISO rate of return at the 10 point some point, you are allowed to do 9.25.
Correct.
Okay. So if that happened last case, what it is, what it is. But this case, To me, that is inconsistent with your 2002 commission order. When you are joining MISO, you agreed to do all-in. This is not an all-in approach. You have to provide all the revenue and cost to the ratepayers, but you are keeping difference between MISO ROE and state ROE. So to me, that's inconsistent with that order. You voluntarily agreed on that matter.
Mr. Halama.
I don't know if there was a question, so.
It was a statement. Anything else on this, Commissioner Hom?
So along that line, if you don't rate base ever in a way, and if you keep using TCR, you can keep abuse that because there is a Supreme Court case that Minnesota court said you can flow through anything in the TCR. That's why I had a concern with whether you are rate basing it or not, whether you are truly using all-in approach versus all-out approach. To me, that is all-out approach effectively. So that's why I think we have to think about how we pursue this issue clearly, whether it's all-in approach. Name doesn't matter. Money does matter. If money doesn't come to ratepayer 100%, it's not an all-in approach. It is same as all-out approach.
I have another question on the unresolved, or excuse me, in the resolved issues, and it's on the wildfire mitigation program. And the staff briefing papers suggest that in 1139 that Xcel should develop a wildfire mitigation plan and then file it in the current IDP, which we're taking up pretty soon. And so I'm just curious how the company and then whoever else wants to weigh in on that topic feels about the staff recommendation of 1139.
Yeah, Madam Chair, obviously, like you said, you're taking up our last IDP very soon. We have committed and we're planning to file a wildfire mitigation plan in our next IDP.
Meaning the one filed like in
Correct. I think it's
May
November,
or so?
I think it's November of.
Okay. And does the department or the OAG have thoughts on that 1139 they wanted, or anyone else they wanted to weigh in on?
Chair Sieben, the department is fine with that.
Madam Chair.
Mm-hmm.
I just wanted to make sure I correct something. You said May and I said November. I just wanted to make sure it's November of 27. That's when we would file our next IDP.
So when the staff recommendation says you'd file a wildfire mitigation plan, your preference or what you're saying is that would need to happen in 2027.
Right.
Not the results that could be decided in your IDP. So we need to kind of modify that 1139.
Correct, and we're fine with that.
And you're fine with that, the department?
Yes, Chair Sieben.
Okay. Anybody, any other, we're finishing up volume 1, but wrap up questions in here. Commissioner Sullivan.
I have a question for, I think it would be on the ROE, well, it's definitely on the ROE side with regard to, I know we haven't gotten there yet, but with regard to things that we've talked about, like with the true-ups. And so if we did a true-up on prepaid pension, which is where I thought Commissioner Hom was going, maybe. If we did a true-up on the insurance costs, I'm curious how many basis points do you think that would represent? Because that's protection, and that seems to lower risk. And people might not have that number offhand, but I'd be curious if that would be something that people would think on. Mr. Dornfeld.
Chair Sieben and Commissioner Sullivan, I think you raised an interesting point, which is that the rate of return is to compensate a company for your assuming business risk. And a true up almost certainly reduces that risk because it guarantees recovery. If you just give me 2 seconds, I can tell you what a basis point is worth in this case. I want to say it's $107,000 or $108,000, but I don't to give you the wrong number.
What is he looking for?
What 1 basis point is
It's
worth?
like 900 and some thousand. 1 basis point is like 920 or something like that.
I'm getting confused with the gas case.
Okay.
It's a little different. 980,000.
Seem a little low. Sure.
Commissioner Sanders, is it gross up number or just raw number?
It's a raw number.
We have to multiply 1.4 to it.
Because I guess the question is at some level, like, how many millions of dollars of protection does this offer you? And that can be converted into a basis point. Mr. Maratsko.
Madam Chair, Commissioner Sullivan, just to draw your attention to page 12 of our exceptions, where we talk about the number of adjustments. And so I think this is relevant to your question without necessarily hitting on the value of the basis point adjustment. Only 7 other companies have held the same number of adjustment clauses, which is 6+. So if we're adding 1, 2, 3 or more, we would need to know how many other companies in the proxy group would actually have whatever that new number is. And if we're getting down to no one, then that supports a pretty big adjustment, right? Because if we look back at, Department Exhibit 26, which was the financial statements from Xcel, over half of the earnings per share growth over the 23-24 period came from NSP Minnesota, which was due in large part because, according to Xcel, they had growth and revenue recovery. So we're ensuring revenue recovery, and NSP Minnesota is driving the earnings per share growth of XEI. That's really important for the commission to consider.
That's all I have.
Okay, any other questions on volume 1? Let's take a quick break and come back for volume 2 after 5 minutes. The commission stands in recess. the commission will come back from its recess and we'll move along to volume 2. And we'll begin with Commissioner Hom.
Thank you, Chair Stephen. So I'll start with another settled issue, capital structure. So it is very interesting that department is the only one actually had any significant testimony, not other parties. I know some mentioned, but not serious testimony. And then according to what I got, it's a settled issue. So department agree with the company's capital structure in general. Is it true?
Good afternoon, Madam Chair, Commissioner Hom. Craig Adonisio for the Department of Commerce. Yes, it's a settled issue.
Okay. I know because you settled because it's been like this, so you didn't spend your time. You have to pick and choose what you need to do, so you focus on ROE, right? You don't have to say it. Okay. Given that, I had a concern, and I raised this concern multiple times, that holding company is double leveraging. How can we reflect that double leverage in capital structure of the rate case? We are not doing rate case for the Xcel holding company, right? Today, we are doing NSP Minnesota.
Madam Chair, Commissioner Hom, that's correct.
And then
The little green light's on. Do I just need to get closer? Okay. Mouth right on the mic.
my recollection, and then I might be wrong, is the Xcel deviate and got more than 50% of the capital in cap structure is due to imputation of the PPA. I don't know whether you have an institutional memory on that issue.
Madam Chair, Commissioner Hom, we don't impute PPAs for purposes of rate setting. It's a factor in credit ratings and kind of overall financial.
I understand this is your position, but that's how companies that keep pushing. They want a higher capital structure to impute that debt. Do you remember any of the company testimony in prior cases?
Madam Chair, Commissioner Homs, yes, a little bit.
Okay. Have you seen any company testimony asking low capital structure due to their holding company capital structure? Because their holding company is highly leveraged.
Madam Chair, Commissioner Hom, no, I have not seen that.
And then I don't know whether it's your knowledge that S&P, when they are issuing credit rating, holding company credit rating does matter to the sub, and then their holding company capital structure does matter to the operating company's credit rating.
Madam Chair, Commissioner Hom, the parent company's credit rating does play a role in kind of the credit ratings agency's assessment of the linkages between the parent and the subsidiary matters, yes, and that's a factor.
Okay, so worst case, if holding company have a 40-60 capital structure, 40% capital, debt 60, which is a 2-to-1 leverage, why don't we ask operating company has same capital structure rather than hypothetical 52-48, which is based on I don't know what these days, because we keep repeating same thing.
Madam Chair, Commissioner Hom, it is possible, I don't think it's the case for Xcel, but it is possible generally for a parent company to have subsidiaries that operate in other types of business, not just utilities. So it's not always, I don't think it always makes sense for to kind of look through to the parent company's capital structure for that reason. And there's the utility subsidiary issues its own debt, and like you said, the credit ratings of the parent company do influence, but they don't govern, so they can be different. And so because we reflect the cost of debt based on the individual utilities issuances rather than the parent company's issuances, we do get some benefits. We don't talk about the costs of doing that enough, I think. But
I think it's a data point. The parent company capital structures can be a data point. Like, why would it make sense for the parent company to have much more debt than the utility operating subsidiary? But I don't think it should be, I don't think we should look through and use the parent company capital structure.
Yeah, but I think we are not talking about that. I think operating company debt rate is really, really good because ratepayers are guaranteeing their debt, and then we are providing steady stream of revenue to pay off that debt. And then also, I think our regulatory model is helping them to get a low debt rating or whatever debt they are getting it. And sometimes also they're using their asset to guarantee payoff, right? So that's a separate issue. My concern is holding company borrow money and inject that as equity to the operating company. Do you think it's fair to the ratepayers? If holding company borrow money at the 6% and then they're asking 10.7% ROE on that debt?
Madam Chair, Commissioner Hom, I think there is, again, I would say that those are relevant data points when considering what the appropriate reasonable ROE should be. Like it wouldn't make sense if that's happening where the parent company's borrowing low and then injecting as equity into the subsidiary. That only makes sense if the ROE is like significantly above the cost of equity. So I think that's kind of the appropriate frame is not, and maybe this is what you're getting at, and I'm just misunderstanding, but again, it's we don't want to look through to the parent company and use that capital structure or anything like that. We want to, but that is like a very relevant data point for setting authorized ROE and capital structure.
Yeah, I mean, either we can use ROE to compensate that, but also we can use a cap structure to compensate that potential extra benefit using financial engineering by holding company, injecting capital through this debt borrowing, because that's a pure arbitrage, and that's not fair to ratepayers.
Madam Chair, Commissioner Hom, I understand what you're saying, and I agree with it in principle. I'm not sure I would agree that it's a pure arbitrage, and I wouldn't go that far, but I do think it is a very significant data point. If it looks like the parent company is double leveraging, that's a sign that they're probably over-earning what their economic needs at the utility.
I mean, I have seen a lot of information, including that we just allowed to have an administrative notice on their 10K. Companies' earning is very different from what they're claiming in the regulatory earning. And the only difference that can come in two ways. One is leverage, double leverage, or they have a significant non-reg operation. But based on Xcel testimony and then some small portion of the data they provide, only 0.15%, that's the number I was quoting. The executives or the top leaders are assigning their cost to the non-reg. That's a signal that they don't have a much non-reg operation.
Madam Chair, Commissioner Hom, I agree with that statement, yeah.
Yeah, so that's why I have a very significant concern with we settle with that 52 to 48 cap structure. We have to think about it, how to be fair to the ratepayers.
Madam Chair, Commissioner Hom, I agree. Again, I would look at it more through the frame of we want to get a reasonable assessment of what a utility capital structure ought to be. I don't think we have that in the record, as you mentioned. That's kind of drove that recommendation for a more robust analysis in their next rate case.
Okay, thank you. So I have a more question on the ROE section, but if... Okay.
Go ahead.
Okay, so this is another detail in the weird thing. So I look into how you screen proxy group. And then I was very surprised that Duke Energy is one of your proxy group member, right?
Madam Chair, Commissioner Hom, I believe so, yeah.
Yeah, I think maybe not all, but most of the this ROE witness proxy group include the Duke. Did you use a Duke operating company or Duke holding company?
Madam Chair, Commissioner Hom, we have to use the holding companies.
Because you don't have any detail of the small guys, right? Same as NSPM.
Madam Chair, Commissioner Hom, we need a stock price.
Yeah. So that's why do you have to use that kind of a super large company to compare with NSPM in terms of size of the revenue?
Madam Chair, Commissioner Hom, I don't know that we have to, but generally speaking, it's in it's a utility company, so it's in the same line of business. There's trade-offs between the number of proxy companies and kind of like tailoring. I'm trying to say, like there's a trade-off between maximizing the number of companies in your proxy group and kind of getting too specific and to match NSPM exactly and getting a smaller sample. So that's just not, I prefer to have more companies in the sample, I guess, generally.
Yeah, so due to the merger and acquisition, if you are still using screening you are using 20 years ago, you may not have a lot of proxy group numbers. That's why you have to use a larger proxy group, relaxing your screening process.
Madam Chair, Commissioner Hom, I think I agree.
Okay. In your proxy group, I don't know whether it's your testimony, but I think one of the testimonies shows that Xcel Energy cap structure was one of the highest in terms of capital. And then there's a lowest, which one is close to 40% too. So I don't know whether it's your testimony or someone else's testimony. Have you reviewed that testimony?
Madam Chair, Commissioner Hom, yeah, that wasn't my testimony, I think.
So can you tell me who has a 40% capital? Sorry.
Give me a minute, I can try to find it. I'm sorry, Madam Chair, Commissioner Hom, I see the minimum is, the minimum equity ratio of the companies in my proxy group is 32.44%. That's who you're looking for?
So which one is it? Company name?
That is CMS Energy Corporation.
So they are in your proxy group?
Madam Chair, Commissioner Hom, yes.
Okay, so in theory, I'm not saying it, I'm suggesting we can go that low. Still, your proxy group is relevant to overall Xcel Energy ROE and cap structure, right?
Madam Chair, Commissioner Hom, yes, it's rougher than perhaps we would all like, but.
I mean, set aside your position. What I'm saying is that's the range you use as your proxy group. So if we go with that, whatever the lowest point within your group is using as an equity portion, if you go that low, still we can make a reasonable decision because that was your proxy group when you're offering your ROE number.
Madam Chair, Commissioner Hom, I'm sorry, I guess I'm not following. So you're saying that we can make a reasonable decision with a company like that in the proxy group, or you're saying we could approve a capital structure like that for NSPM?
Yeah.
I'm sorry, which one?
No, I mean,
or either.
If we, let's say, 32% is the lowest, we say 32% cap structure for the Xcel, still is within the reasonable range because that's your proxy group.
Madam Chair, Commissioner Hom, I wouldn't make that argument, but I guess I understand what you're saying. I mean, that would be a huge abrupt change that would have a significant impact on the company's finances and cash flow.
I understand. That's why I'm not suggesting that number. I'm just doing theoretical work. My concern is all ROE testimony using very similar screening process and similar proxy group. How can I trust your numbers? Because that kind of extreme case, even you cannot agree on the capital structure of 32%, that is a part of your proxy group. How can I trust anybody's testimony here?
Chair Stephen, Commissioner Hom, I think the purpose of the proxy company is to provide a reasonable range of companies. No one company obviously is an exact fit for NSPM, but as a collective whole, the idea is for the proxy group to provide sort of a rough estimate of kind of what's in the range of reasonable. I think some of the reticence you heard from Mr. Adonisio is that no one company is supposed to be a perfect fit. So sort of attempting to use the capital structure of another company and saying, well, that because it's in the proxy group, it must be appropriate for NSPM. That might be a bridge too far. The purpose of the company is to kind of provide a sort of a reasonable range with the understanding that NSPM falls within it.
I understand difficulty of creating proxy group. That's why I start with that. Given that, also, we traditionally use a two-step DCF, but now everything is changing. That's my point. Everything is changing. We have so much problem creating proxy group, which is a fundamental of this ROE decision-making process. That is being shaken. What is the best way of deciding ROE methodology-wise? Should we stay with a two-stage DCF, or should we move on, or what should we do? I mean, I understand you use a different method this time. That's why I understand many different witnesses was using different method. I can take any methodology given the uncertainty with the proxy group as of now, unless somebody's making really good arguments about it. So that's why I was asking you about this uncertainty with the proxy group, and potentially, in your view, going with the 32% equity is unreasonable. I understand. So that's why I think we have to give a lot of thought in the capital structure, even it's a settled issue, and then ROE, and using this proxy group and different DCF methodology, or even other way to evaluate what is a just and reasonable return to the company. I think the department can agree with it.
Commissioner Hom, I just think one point of clarification. The department's testimony and position in this case is not that we've settled capital structure. The department looked at it, offered testimony on it, offered some recommendations for improvements going forward, and took Xcel's proposed capital structure into consideration in developing its overall ROE recommendation. There's not an agreement that the department has said that the capital structure is reasonable or that it couldn't be changed. This isn't a settled case. I would say it's sort of an issue that was disputed, but with sort of less degree to say ROE or some other issue in this case.
Yeah, thank you for that clarification. That's why I said you just let go because you have to spend more time on the ROE. And that's how I start this statement. So I understand, difficulty of you spending all the time on something. You have a challenge explaining things based on what you have in duty. So yes, thank you. So I'm not trying to push you back on what you did, but I just want to make sure that we have reality of what's going on, given that we have to find just and reasonable rate, so we have a very difficult time to do it. I'm not just blaming you, it's not your fault.
Yeah, Madam Chair, I'm not going to spend any time on the historical fiction built on assumptions this time around. I appreciate the record is pretty, I think, pretty robust in this area, thanks to XLI and Cub and the department for their analysis, and also for the company. I think I have plenty there. There was a lot of discussion about the legal issues. I found that quite interesting in this case, and I am looking at what I would say, if you go to page 44 and 45 of volume 2 of the briefing papers, you will see the ALJ's findings, 992, 993, and 994, where he recommends the 9.8 ROE. And I don't know, Mr. Anizo, you could probably correct me. I don't know if I've seen a spread this big. I got a 163-point spread between where he started at the bottom, which was your recommendation versus the company's recommendation. I don't know if I remember a spread quite that big. I don't know if you do or not, but that's a pretty big spread. And I seem to not be remembering either one either. But I'm looking at this from a legal analysis. I'm reading his findings. Let's say I agree with the 9.8. I agree with the ALJ. The ALJ is correct. And if I were to adopt 992, 993, and 994, particularly 994D, where he kind of makes an assessment, and having read Bluefield and Hope, and also the Minnesota case of Hibbing taconite, I just want to know from the company, that's what I adopted. That's my findings. I told Mr. Blodgett, that's all we need to put in there. We're gonna do the ALJ. Would you see that analysis, particularly 994D, and just all the overall analysis, a violation of Tack Harbor or Hope and Bluefield?
Madam Chair, Commissioner Tuma, there's been a lot to respond to, and I hope for the company's sake that I get an opportunity, and Mr. Novak gets an opportunity to respond to some of the capital structure discussion, since that was not a contested issue in the proceeding. On this, it's certainly not the way we have interpreted what would be a reasonable range. Our reasonable range.
You know what the reasonable range? I'm talking about the legal
bottomed
aspect.
out.
Is this legally sound? Whether you agree with 9.8 or not, it seems to me that he's not violating. Judge Meyer's a good judge. Don't tell him because he'll get a big head, but I think he's one of the better ones. Okay.
Madam Chair, Commissioner Tuma, I agree.
Okay, so help me out. I mean, I'm just looking at it from the legal analysis. I know you got your factual analysis that you want to push, but I'm just looking at 9.8 and I'm looking at his analysis. It seems to fit within what I would expect, the court would expect from us in Tack Harbor in Minnesota, and from what was the historical Bluefield and Hope decisions.
Madam Chair, Commissioner Tuma, when you phrase it that way, I don't have anything to disagree with. I think clearly Judge Meyer was looking to land somewhere that he felt was an overall reasonable result. And he applied his judgment. You know, there is, on the legal point, I have to say there's a significant difference between applying judgment and moving to your quasi-judicial or policy making. Judges apply judgment. That's why they're called judges. Yeah, he used his judgment and he came to a different conclusion than we did, obviously.
You'd probably be pretty happy with 9.8 if you came out here. You probably would consider that a win, I mean, by my guess, but.
Madam Chair, Commissioner Tuma, I'm not going to go there.
Okay.
But
I know, you
but
got
he,
your position.
He applied his judgment and he did it in my personal opinion, an overall understandable way.
So he was not exercising, and this is where I was frustrated, this quasi-judicial versus quasi-legislative. There was all this debate around it. I'm just looking at the way that the statutes are written, the way the order was written, and particularly in TAC Harbor, we need to come up with a kind of a determination which requires judgment. We're not a formula state. You would agree with that?
Madam Chair, Commissioner Tuma, I do agree with that.
I look at my friends from, the department and from XLI and, Cub 2, I think it was involved in this discussion. I feel if I took this 9.9 or 992 and 993 and 994 and I substituted 9.25 and I substituted in 994D 1/3, okay, that puts me right at 9.25, okay, and I change nothing else. I keep everything else the same. I would think that would be sufficient legal basis for you all to defend a decision under TAC Harbor and Hope and Bluefield. Would you agree with that? Because I'll tell you, I'm pretty comfortable with 9.25, and when I look at this analysis, I just substitute those two numbers. I keep the same exact analysis. I would think you'd have enough to work on, or do you need more?
Mr. Commissioner Tuma?
Yeah.
I just want to make sure I understand your rationale. Can you just repeat how you got to that 9.25 again?
Yeah, 9.25, if you change...
You're on page 44 and 45, right?
45. If you change 994D, it says be approximately 2/3 of the way between the department and the company.
So D, 2/3 of the way.
Say 1/3, and you do the math backwards, that comes out with 9.25, which is the department's recommendation. So I'm just looking at the analysis and the legal fights all here. I want to make sure my order is sufficient to defend, because it became kind of an issue last time, because everybody was talking about quasi-legislative, quasi-judicial. I'm just trying to say, look, here's TAC Harbor, here's Hope and Bluefield, and here's this analysis. If I just change it, I probably would add in there 52% equity. I would probably add in there Cub's analysis on the risk, XLI's 50 points off on the fact that they have all these riders. I would probably put a few other paragraphs in there.
Would you keep the flotation cost?
Huh?
Would you keep the flotation cost?
I would, yeah, flotation cost too. We'll throw that in there while we're at it. Yeah. So I'm looking at you guys. Am I on solid ground legally? You feel defensible?
Chair Sieben, Commissioner Tuma, I'm confident that's something the department would aggressively defend, and I think it is defensible. Setting aside the sort of quasi-judicial, quasi-legislative debate, which I think is more applicable to some of the other financial issues, which are, I would say, evaluated by a different standard. Hope and Bluefield, which clearly applies to rate of return, courts repeatedly say is a pragmatic judgment based on the facts in the record, and there's ample evidence in this record that Xcel's cost of equity is likely lower than 9.25, and certainly maintaining that ROE at 9.25 would do no violence to Hope and Bluefield. I don't know, Mr. Edens, do you have anything else you'd want to add?
No, Mr. Edstrom, I appreciated your analysis. There's a few paragraphs I would pick from you in there and throw in there to get to 1/3 as opposed to 2/3.
Yeah, thank you, Chair Sieben and Commissioner Tuma. And I think in my opinion, the Hope and Bluefield decisions give the Commission wide latitude to make decisions based on what's in the record, using your judgment, however you want to parse that out. But those and other decisions also, make clear that the Commission isn't bound to follow one formula, one model, and encourages you not to rely too heavily on just formulas or models. So I think within that, I understand the Commission has a history of using certain models and relying on them, and but how the Commission uses that and applies it to come up with what it determines is a fair authorized return that balances shareholder and ratepayer interests, I think you have a lot of latitude within that zone of reasonableness that is supported by the record.
Mr. Maraska, I would add a few paragraphs from your analysis, your legal analysis. I thought they were helpful, particularly the discussion about how there are a lower risk utility compared to others in the proxy group. That would probably be a paragraph that I would add to this, but nonetheless, just structurally, is this defensible under Hope Bluefield and Tack Harbor?
Madam Chair, Commissioner Tuma, I would say it's more than defensible because it's more than generous according to XLI's analysis, right? We, given all of what Commissioner Hom pointed out on the difficulty in relying on the financial models and combining that with the testimony from XLI on adequacy to attract capital and sufficient to maintain its financial integrity, I would say that at 9.25, we are more than adequate based on the record to attract capital, and we are more than sufficient to ensure the financial integrity of the utility. So, gosh, it sure seems like that would be quite generous at 9.25 and therefore more than defensible under this record.
Those are all the questions I have.
And I'm just thinking more, Mr. Moratzka, about Commissioner Sullivan's line of questions before the break. And see in the exceptions to the ALJ report, you argued that there should be a downward adjustment to the recommended ROE because of the company's lower risk profile, and I think others mentioned that too. But you came up with a 50 basis point reduction to account for their reduced risk profile. And to kind of re-ask Commissioner Sullivan's question, how did you arrive at 50 basis points? Like, I know they get rider recovery, and we talked about it for meters, for example, earlier. A lot of their costs go through riders, but how did you arrive at 50, and kind of what was more of the rationale for that reduction?
Madam Chair, Commissioners, so there is there's two adjustments. There's a 50 point for reduced risk, and there's 10 point for the customer service. The 50 point reduced risk does account for not just the sheer number of rider recoveries, and
but how is it calculated? Like what? Like
there's
each rider gets 5 points, or like was it just a judgment call on your
There
part?
is judgment, and I would say there's also record reflection that the 50 basis point reduction is fairly close to the amount on a basis point level, right? Fairly close to the actual dollar value of just one rider that the company has, which is the sales true-up. So in applying the judgment to say, well, the cost of this reduction in terms of an annual revenue requirement being directionally close to what the company recovers just in one sales true-up seems to justify, at least from our witnesses' perspective, the value of that 50 basis point true-up. And to follow on Commissioner Sullivan's question, well, aren't you, I think, double dipping by saying here's a 10% basis point reduction on top of a disallowance of costs? XLI's position would be, the rate of return is on the assets that are serving customers. And so you have two pieces here. You have the cost of the service as an expense being problematic, and those assets not being used well. So there's another 10% basis point reduction on the ROE, so that you capture both sides of the abysmal performance, as we noted.
Is it 10% or just 10 basis points?
10 basis points, sorry. I misspoke.
And I can read more into that analysis in where?
Ms. LeConte's testimony.
Her direct?
Her direct, her rebuttal, and her surrebuttal.
And Cub, did you want to add anything about the discussion that just took place between the other commissioners here?
Thank you, Chair Sieben. I think it might be helpful to ask Dr. Keim to come up to maybe talk some about the proxy group issue, with your permission.
Because that will help us understand the risk profile, or what are you getting at with that? Because I'm not sure we could just have a point to where his testimony is and what point you're trying to raise.
Yeah, well, I think on the proxy group discussion, well, I'm sorry, maybe I'm misunderstanding your question.
I was looking for more justification for the reduction in the company's risk profile as compared to that. So I don't know if that's.
Thank you.
Sorry, it wasn't clear.
Yeah, and I don't know that we address that as directly as XLI, but I think where I see that coming into play is there was some emphasis in the ALJ report on, how the average ROE across the country should be factored into, what the commission decides here. And we push back on that in our exceptions, saying that I don't think you should make your decision just on looking at what the average is and where this sits relative to the average. And I think those differences.
And did you say that was because of, in your testimony, sorry to interrupt, because Xcel Minnesota has a lower risk profile too, compared to other?
I don't know if we said that directly in our testimony, but I think where I see that coming into play is, in our view, utilities ROE should be set based on the record before it, based on the modeling results, consideration of other factors, establishing a cost of equity, and then deciding where relative to the cost of equity and ROE should be. That includes considering risk factors. And none of that is captured just by looking at the average authorized ROE across the country and then setting an ROE relative to that average.
And for the company, you certainly can respond to the overall discussion about capital structure, but Mr. Swanson, we don't want to relitigate the last rate case, but we do remember how the reaction, at least I remember the reaction of the company to our determination of a 9.25. And I think ultimately, we made a reasonable judgment call, and the record evidence in this case now shows that it didn't lead to harm, as the company sort of, to paraphrase, said after the last rate case decision. And so overall, what is your response to the lowering of the judges, the discussion that just happened about keeping your ROE at 9.25? Your risk profile hasn't changed since the authorized return that you have now. If anything, we've seen an increase in costs going into riders and other mechanisms that I think have allowed the company to maintain a good, overall market position and things like that are in the record. So please respond to just why 9.25 is unfair in your estimation.
Sure, thank you. Thank you, Madam Chair, and I'll try to be brief on the capital structure issue as well. On 9.25, I think one of the most salient points is the number of objective measures that indicate that the cost of equity has gone up since you set that. That was set based on the two growth, based on two growths from two different points in time. But every two growth in this record shows a cost of equity above 10. Not one of the proxy group companies in either the department's or company's updated two growth analyses show an ROE below 9.5. The 18-month trailing average for authorized ROEs has increased by 30 basis points since the last case. Since the last case, no vertically integrated utility has received a 9.25 or lower. So Commissioner Tuma, to the Hope and Bluefield comparability would say that's an interesting data point. Not one utility, vertically integrated utility, has received a 9.25 or below. So I think there are a number of objective measures there, and I think the judge took those into account. I also think it's important to recognize that some of what's been discussed today would be a dramatic change in regulation in Minnesota.
I thought that was the last rate case was going to be a dramatic change if we landed at 9.25.
We went up from 9.06.
Madam Chair, no. I mean, we currently have an approved capital structure of 9.50. It's been in place for 20 years. Customers have had the benefit of that. If you look at the long-term debt schedule in Mr. Wayner's testimony, all of the long-term debt, except one small issuance, has been issued when the company's had roughly a 52% equity ratio. Our credit rating agencies say that's a key consideration when they attach ratings to NSPM, which has its standalone rating. If we're looking at now changing what is a currently approved and for 2 decades approved capital structure, that's a dramatic change. If we're looking at accepting and putting 2/3 weight on a multi-stage DCF analysis that uses U.S. GDP growth as the terminal growth rate, when it's never been approved by the Commission before, that's a dramatic change. These will have consequences. We didn't agree with the judge, obviously. We think we made a case for higher, but the judge at least did seek to consider the changes since that last rate case decision and reflect it in his recommendation.
Sorry, I didn't mean to cut you off about the capital structure. Is there anything else you wanted to say on how you think that if we moved away from what the capital structure has been, because it was settled, there wasn't a lot of record development, so I'm like trying to follow Commissioner Ham's line of questioning, but also like understand what that would really mean. That I need your response to that.
Madam Chair, because there isn't a record, I don't know what it would mean. No one suggested a capital structure below 52.5%. And I think for a lot of good reasons that I'm happy to run through if you want to hear them. But the fact is there isn't a record.
And if you would dip below the 52%, give us like the top couple reasons why it would be problematic, or where we point to in the record to read about why that's really problematic in your...
Unfortunately, Madam Chair, our company treasurer isn't with us today, who is our capital structure witness, who could give you
testimony is in
give
it?
you chapter and verse. Yes, his testimony is in. He was more discussing why 52.50% was the right number in his direct testimony, and then when there was no pushback, there necessarily wasn't a discussion of what happens if we go down to 50 to 40 to in the 30s. What is in the record is Moody's and other rating agencies' strong consideration of the equity ratio in assigning a credit rating to NSPM.
And is the capital structure different in other Xcel operating states?
Madam Chair, I can't give you the details on that, but I don't think it is in the record, but you could, there are publicly available decisions that show that, yes, other subsidiaries actually have higher equity ratios.
But not lower? Or you don't know?
Madam Chair, I don't know on that.
I haven't read it, but.
Madam Chair, I do know 2 of them. Which of the big ones is? It is. I might get them backwards, but I believe it is Piesco, which is a Colorado subsidiary, as a 55% equity ratio, and SPS, our Texas New Mexico, is 54.5. That may be reversed, but those are the two numbers.
Okay. Thank you. Commissioner Hahn.
Thank you, Chair Stephen. Okay, don't oversell credit rating agency statement. I think we have gotten same training and education from those guys. It is one component of their credit rating method. And also that buyer, they have a different perspective compared to the equity buyer. And then that buyer's biggest concern is cash flow, not the ROE. ROE is more concern of equity buyer. And then equity buyer also has a biggest concern, not the absolute ROE, but difference or lack of difference between actual earning versus ROE. You guys are earning a lot higher than allowed ROE based on your number. So that's why you are the darling of the institutional investor. A lot of institutional investors own your stock. So I'm tracking all our utility, those investor-owned utility, the investors' percent of their, you are between 90 to 100% institutional buyers are buying it. That means your equity is very attractive. So yes, we are doing our own homework. So don't try to oversell that. Credit rating agencies a certain statement and then selling that as, yes, sky's falling. Because I made it clear, there's a record. Proxy group with 32% equity, they are in the same proxy group, creating your ROE number. I don't know whether they are in your proxy group, but clearly there is a one in proxy group. That's in the record. We can go below 50%, and still they can be part of the group. But as I said, it is part of the whole picture. Whether we have a lot of true up, or we have other things, and also there is some balance between ROE and cap structure at the end. I think Mr. Eugenio was suggesting that rather than cap structure, he preferred to see that reflected in that if your holding companies are double leveraged. Your double leverage is in the record too, right? Under the 10K, that number is visible. So everything is in the record.
Commissioner Sullivan.
I have a couple quick things, I think. But one is, and Mr. Swanson, I'd really like to hear more from the company about like the advantages of the current cap structure. Like you said that, you know, you guys would get that, but I would really like to hear more about, you know, why the company has seen it in shareholders, or not just share, but why the company sees it in shareholders and ratepayers' interests to keep it at 52.5, you know, for the last 2 decades or decade. I think that is important. And the other question that I have is that a 9.25, which obviously is the current ROE, there are some things that I am thinking about. In particular, I'm thinking about the inflationary environment that we're in. And I'm wondering if you could speak to that. How many, like, does the company have a thought on how many basis points that is? Like, I'm actually kind of thinking about this very systematically, factually, and, you know, trying to put the pieces of the puzzle together.
Sure. Thank you, Madam Chair, Commissioner Sullivan. On the 52.5, there are a number of reasons that we think it's the right number and a reasonable number. Certainly history and predictability is one of those. Predictability is important. Predictability and consistency in regulatory decisions is important. It helps us when we go to the capital markets. We also think it's appropriate because of the nature of NSPM. It's a standalone corporation. It issues its own debt. It manages its own capital structure. I take issue with calling it a hypothetical capital structure. It's not. NSPM issues its own debt, has its own credit rating. And I think, as I said before, you've seen the benefit of this in the cost of long-term debt for the company. The company gets very favorable issuances. And while we can debate how much the credit rating agencies look to one item or another, I'm just quoting them when they say it's a key consideration. And also, this methodology that the Commission has used, which looks to the capital structure of the OpCo, I mean, NSPM is not different than the other operating companies in the proxy group. Those ranges of equity ratios were quite different. We are not different than the industry in having a holdco that has a lower equity ratio. The other OpCos, the average equity ratio was right around 52.5 in Mr. Novak's testimony. And that's consistent with the way FERC has looked at these issues as well. They have a very well-established three-part test for when do you use the OpCo, when do you go to the parent. We meet that three-point test. So we think, along with the fact that there simply isn't a record of what impact a lower equity ratio would have, this is not the time to be changing the equity ratio. In the last capital structure docket, you required the company in its next filing to provide additional information, and will do that. The department had some recommendations for what they want to see in the next rate case. We were troubled by some of those recommendations because we thought they might create a completeness issue because we're not quite sure what the department wants, but we're happy to build a more fulsome record in the future on these issues. This is not the time. And if I could briefly address the risk issue, because that's come up a lot, I'd encourage you not just to read Ms. LeConte's testimony, but read her cross-examination and read the report that we submitted during her cross-examination that actually explained the mechanisms of all the different companies, because Xcel is not different. The point is comparability. Is the sales true up? Can the sales true up be worth a lot of money? Yes. Does almost every other operating company have a similar mechanism? Yes. The devil's in the details on these things. So I'd encourage you to actually look at the full study that she used to make her claims, because we think it actually supports us. And that's why we introduced it into the record.
What about inflation?
I mean, Madam Chair, Commissioner Sullivan, you can't put a basis point number on that. I mean, unfortunately, right now we're all seeing what we hope is a temporary spike in inflation. It's impacting the company just like it's impacting our customers. We hope that doesn't persist, but I don't know how you can reasonably factor that into finding the right landing spot.
So, Mr. Swanson, I hear you say that about, and I will look at the, her testimony as well as the cross-examination. I will look at that. But when I do think of ROE, I mean, I think of it as a calculation of risk, and that if you have, riders and true-ups and multi-year rate cases, many, many different mechanisms to recover those resources, and on top of that, you serve the most economically vibrant part of the state and the upper Midwest, like, you don't have as much risk as, certainly as Minnesota Power or Otter Tail or other groups, other utilities potentially in that proxy. I mean, that's a global statement, but I mean, it is a recognition of risk. So, like, I feel free to respond, but I mean.
Yeah, and Mr. Novak may have thoughts too, but again, it gets back to comparability. And when we're pegging the ROE to a comparable group, the relevant question is NSPM more insulated than the comparable group companies? And we don't think there's a record that supports that claim.
Yeah, Madam Chair, and
Commissioner
Mr.
Chu.
Anizio, I remember a conversation in past rate cases about inflation and ROE, and I remember it had a converse. I mean, I was thinking higher inflation, higher ROE, but actually in some ways, the historical evidence on that wasn't true, but I could be mistaken, and I don't remember if the conversation was with you or somebody else, but I was, do you know that?
Madam Chair, Commissioner Tuma, I don't recall that conversation.
Yeah, I think it was somebody else. That was Ms. Bulkley, I think, if I remember right. It was probably in your rate case.
Yeah, Madam Chair, Commissioner Tuma, I mean, to the extent inflation has an impact, it really is an indirect impact. Where it has a bigger impact is on cost of debt.
That's what I thought.
Can I just say one more thing on, I mean, like, we can get into some super, as we are currently in, a very esoteric conversation, or this is all going all over the place. But my baseline is that, like I said, it's a calculation risk, and then I look at the models, and then I start, and I've done this now several times, and my methodology is fairly straightforward, and I always try to tell people what I'm doing and what I'm thinking. And the last go-round, I looked at the midpoint, and then actually XLI's recommendation was take 50 basis points off of that, and that's where I got to my number, which I think was 9.40. I mean, and for me, like, that feels pretty straightforward. It doesn't deal with the cap structure, but it's straightforward, and it sits certainly within our kind of fact-finding analysis that we do here. If necessary, you move somebody in or out of the proxy group, but I don't know. My thinking is that we should be straightforward on this and not try to jump up and down on the ice.
The other point that you made, Commissioner Sullivan, that I think is relevant here is that, and I'm not trying to put you on the spot, Commissioner Hom, but it's hard to figure out and land at an ROE if we don't know how the capital structure could change or what you're thinking. And so I don't know if you can say more about what you're thinking based on your earlier discussion and your reading of the record, but for me, like being deciding like on something as important as this, that's why I wanted to have commissioners file tomorrow some of what they were thinking, and I don't know if you're ready to do that tomorrow, but like if I'm going to get to a point where I support changing the capital structure, I just need to have more information in this record about why that's reasonable to do at this point. Otherwise, it just feels a little too uncertain for me.
Yeah, thank you, Chair Stephen. I understand other commissioners will be nervous about it because Xcel Energy and all utilities keep saying our credit rating agency says so. Okay, I think that's why I like to talk with those guys, and I had a conversation multiple times. Being said, that's not in the record, so I'm not going to sell that. But also, I want to push back on the company claiming that that's the Bible. Being said, I'm not going to propose 32%. No, I was pointed out how potentially bad that proxy group is. That was my point.
The department.
No, everybody has that problem, not just the department. Duke Energy size is very different from NSPM. That's one example. Another example I gave was that very extreme cap structure. I don't think that's good for the company either. So don't be scared. Being said, I have a concern with the double leverage. Company didn't do any good job defending it. Only hypothetical answer based on what I read, their testimony was, oh, that money could have been used for the non-reg. But one of the party pointed out that there is only 0.15% of allocation of executive or top group salary to the non-reg was a 0.15%. So that's the evidence I have in the record. Their double leverage is not properly addressed. So if I want to directly address the double leverage, it has to be 40%. Even I don't want to go that far because I agree with you. We shouldn't deviate too much from the as of today. We may go that direction, but I'm not going to go that drastic. So that much I can say.
Okay, any other questions on this volume or thoughts to share? No? Volume 3, the sales forecast. Commissioner Hahn.
Thank you, Chair Stephen. Sorry to bother another settled issue, but I am very troubled with that settle because load forecasting is not just being used in the sales revenue calculation. It has to be used in many different places. I don't know whether there was any good settlement on how to use a settled number in the creating allocator in the CCUSS. So I'll ask a company, what is your idea by just using actual in place of your load forecasting and you just close out that difference between you and department?
Madam Chair, Commissioner Hum, I don't know that we're totally following. You mentioned the CCOSS, and I think I'm getting my words crossed.
So when you're allocating cost, don't you need the customer number projection for the tax year or sales revenue? Don't you need those numbers to doing CCOSS?
Yeah, I think I'm confused because I think the CCOSS is being discussed in Volume 4.
No, but input to that CCOSS. Load forecasting is not just a sales revenue calculation. That's what I am trying to say. You settle with using actual number as a resolution. Does it address concern with the CCOSS? Department witness even mentioned that in testimony.
Okay. Mr. Barlow is our CCOSS attorney.
Thank you, Chair. Commissioner Hom. I think that, as I understand, you're asking, have we made any changes to the sales that were used to calculate the cost of service study? The answer is no.
So that is a potential gap, but I'm not going to touch it here. But do you mind if I suggest find the resolution with the department before next rate case as an additional condition to this settled issue? Do you have any concern?
Madam Chair, Commissioner Hom, I don't have any concern with you telling us to go to the department and try to work this out. Obviously, to resolve an issue takes both parties to try to resolve it, but we're happy to give it a shot.
Okay, then I'll ask the department.
Chair Stephen, Commissioner Hom, the department's always happy to talk with the company and try to resolve issues.
Yeah, because I'm very surprised that your initial testimony say, oh yeah, this has an impact to CCOSS. But in the rebuttal, oh yeah, we settled because sales revenue is done. There's a gap. So I hope that is being properly addressed in next rate case. Before next rate case, I hope we don't have any difference in there.
Any other questions on Volume 3? Volume 4, CCOS, Commissioner Tuma.
You know, I'm pretty comfortable with our past practice. I'll look to OAG and the department, in particular OAG, because you always have weighed in effectively in the past, but I'm kind of the opinion that 401 and then nothing else other than what we might like in the next rate case. We'll talk about those different iterations of what the next rate case would be, but I'm kind of comfortable with our normal practice there, and so any concerns with that approach, Mr. Schultz?
Madam Chair, Commissioner Tuma, no concerns with that. I think that has been your historical approach, and we don't feel you need to adopt any specific CCOSS model here.
Department?
Chair Sabin, Commissioner Tuma, Amrit Hundal, Assistant Attorney General for the Department of Commerce. The department also supports decision option 4001, 4001.
Sorry, I couldn't hear you.
4001. The department supports that decision option.
4001, yeah. And then, before we talk about the next rate case, I would just assume from the company that you're okay with us doing 4001 and then talk about future rate case separately.
Commissioner Tuma, we're comfortable that the commission doesn't need to adopt a specific study in this case, although we do note that the ALJ included some pretty specific findings about the comparative value of the different studies. We're comfortable with 4001. We did provide an alternative for the commission to consider in our letter, but they're fairly similar.
I mean, I think that, you know, his analysis is good, it's helpful, but it's, you know, it's what it is. You know, well, we always use a wide range. I did like table 1. I mean, it was helpful when I compared table 1 of section 4 to table 1 of section or volume 5. I think it is instructive, and it'll probably help me frame how the class cost of service would reflect in the rate design. But that's a separate issue. But I really thought table 1 kind of was a helpful piece of information, and it fits within our normal process. Really quick on future rate cases, so we're tracking. There were some late files or different filed items in that, so I'm looking to first 4005 A or 4008, and so that's the staff dealing with the D10S allocator and the 10 CP. So our staff said ordered to the best available actual study usage historical peak to calculate the D10S allocator in future cases. So Mr. Schultz, you had indicated some preferences, and you saw, I assume, also the 4005A that the Xcel has filed. What is your position as we sit here today?
Just one moment. I'm getting to the decision options here.
Yeah, we're getting into the weeds, but
The 4005A says, in future rate case proceedings, the company should calculate the D10S allocator based on the NSP system peak, if that helps.
That helps. Thank you, Madam Chair. And Commissioner Tuma, so 4005A that Xcel submitted, that would be, in our understanding, a reversal of the Commission's practice in the last 2 rate cases where it decided that the peak demand allocator should reflect Xcel's obligations under MISO rules for capacity obligations and treat cost causation that way. So we would oppose that. Is that what you're looking for?
Yep, that's what I'm looking for. What your position is?
And yeah, and the reasons are for those that the Commission stated in prior orders, and I'm sure you're aware of, which is with the advent of MISO, Xcel has for some time been planning its capacity with reference to MISO's requirements, its resource adequacy requirements. So that's in a nutshell why we support that Commission continuing to use that method.
Now you suggested also doing the 12 CP. Our staff changed that slightly to say, best available. So I don't know if you had a position between your 407 and the staff's new 408.
And I think we.
And you mean your amended 408, Mr. Schultz, right? Or can you just clarify what that does too?
Yeah, my apologies.
No, it's just, there's a lot of changes.
So for the, yeah, so just to be clear, our recommendation is that we think the commission should, in future rate cases, direct Xcel to move towards a peak demand allocator that is a 12 CP allocator that considers the class load shares in each of the 12 monthly peaks. With regard to how we find the MISO peak, you know, that's only possible with historical data because MISO doesn't publish a forecasted peaks. And so the commission would be, hopefully Xcel in the next rate case would have class load data, you know, coincident with the MISO peaks, whether you stay with a 1 CP or move to a 12 CP, or whether you stick to a single peak or move to a 12 CP, you would hopefully have historical data, like as staff, I think, supports as well. The thing we've run into is that, you know, Xcel hasn't had that. AMI meters hadn't been rolled out until recently, and I'm not, as I sit here, confident whether there will be good data even in the next rate case if it's filed, say, this fall. So in that case, we'd recommend that the commission order Xcel to do something similar to what Dr. Sharber did in this case, which was to look at the hours that MISO has tended to peak and apply that to Xcel's sales forecast and look at the class load shares at those times to create sort of a composite representative peak hour, or a representative class load share at the peak hour. Or
Right
hours.
now, as you stand, you still support then what your June 8th letter indicated for 4007 and 4008, both of those.
That's correct, yes.
And just to Xcel real quick, any concerns, any positions?
Are you opposed to 4007 and 4008 as amended?
Thank you, Chair Commissioner Tuma. The first thing I just want to say is I think that there's actually less distance between the company and the OAG than it probably looks like from the record, and that this is more of a data availability problem. And our hope for this case is that we can get direction from the commission on something that we can actually execute and not have to keep having this fight in the next, you know, in a future rate case. There's two big problems with data availability. One is that there is a problem using historical data in a rate case because there can be significant differences between, you know, the historical data for this case was from 2003 and 2004, but we're now in 2006. And as the company's load profile changes over time, which could happen rapidly, there can be significant problems there. And the second is that when we look forward, MISO just doesn't tell you what day is going to peak in a future test year. And so we can't calculate exactly based on that. There are two potential data sources. We do a forecast for our forward-looking test years, and we forecast that very precisely, and we have a peak, and we have forecasted class hours and usage at that time. In the future, when we have good data from AMI, we will have historical usage. And so I think in concept, you know, the OAG's amendment to 4008 could be a path forward, but we don't exactly, I don't know that we're totally fully aligned. So our preference in this case is like 4005, we've got it, something usable for the commission in this case. For the next case, we would prefer not to be required to use historical data because of the possible problems caused by the time differentials.
So which ones do you support, Mr. Barlow? Because the time is getting late here.
Yeah, my suggestion, Madam Chair, actually is this. I mean, this doesn't have any financial issues. If you guys can talk and come up with a 4,005 through 8, that would be appreciated. And I think there is some, from what I'm hearing, there is some potential along these lines where as practically available or something along that line. So is that okay with you, Mr. Schultz?
Madam Chair, Commissioner Toomey, you would just like to, the OAG and Xcel to see if we can come to some agreement before Thursday.
Before tomorrow.
for tomorrow.
Well, I don't feel a need, you know, I've been looking at this to enter in decision options by tomorrow. I don't see this being a financial impact, so if you can work it out, we'll work with it next week too,
Yeah,
but
I was just kidding.
sooner
It
the
doesn't
better.
have to
Well,
be by tomorrow.
I was okay with it. And then, really quick, I'm looking at, decision option, future, again, looking at the future ones, would be 18, 4018. And I see that you have a 4018A, and, is that, I guess, acceptable? The changes the company, or the OAG has, is that acceptable to the company, or do I have to analyze this and put an option together?
Thank you, Chair Commissioner Tuma. We are in agreement with 4018, and I'm sorry that we didn't note that.
But what about A?
With A, if
4018A.
the commission wants us to file 3 studies, we will do that. Our preference would be not to file a peak and average study in the next case. They are very time consuming, and there's a good record in this case, and the ALJ recommended that it's substantially less useful. We will make one if the commission directs us to, but it's a not insignificant commitment of time, and then it perpetuates through the case, because every time we're asked to update the cost of service study, we have to update that one as well, and it takes
So you're okay with
many work.
4018 as it is in the briefing papers? You have some concerns with 18A. Mr. Schultz, your quick word on it, so I can talk to staff about this.
Madam Chair, Commissioner Tuma, I think we suggested 4018A because it was our recommendation and wasn't reflected in the decision options. I think 4018 is the department's recommendation. The commission has, at least in the last rate case, required all 3 studies, types of distribution, system allocation, or classification to be filed with the initial filing. We're going to ask for it, I can guarantee you, so they're going to have to do it anyway. So they might as well. What we found in the last case was there was mistakes made when we asked it to be done in discovery, and then we didn't find out till the last minute. So having it in the initial filing gives the company more time to get it right, gives us more time to look at it. So that's why we recommended it.
They're gonna have to do it anyway, so.
Got it.
And then, real quick, staff, was, liking 4020, and next rate case filing. Department, ALJ recommended it, for OAG and the company. Any concerns with 20? I see the company has a 20 alternative, so.
Thank you, Chair Commissioner Tuma. As we discussed earlier with Commissioner Sullivan, we are open to and willing to do a meter study. I do just want to respond to Mr. Schultz's note. We're not going to do just a simple study comparing costs. We're planning to take this seriously and do a solid analysis on what cost allocations make sense. Our preference was that the commission not prejudge what the outcomes of that study are and let us do the work and come back with something that makes sense.
DOC, they changed 20. Any concerns with the change they made?
Chair Sieben, Commissioner Tuma, I don't believe the department has concerns with that. The
No, I
department's
think that-
preferred decision option is 4020, but any study that furthers our understanding of this issue is useful.
Did you understand that? I thought they were proposing the
I
change.
did, and staff will
Okay.
understand it, because when I ask about it, we'll talk. Mr. Schultz, any concern about the amended 20?
I guess the OAG doesn't see what's wrong with the original 4020, but as amended, it just asks them to compare the cost of the 2 meters. I'm not sure what that tells us, but I guess it sounds like they're going to do some in-depth analysis, so that's helpful to hear.
And lastly, in this area, I think you've recommended a 4025. In the next rate case, Xcel should allocate economic development costs using equal weighted average of Xcel's energy and peak demand allocator. I think this is somewhat different than what is in 2023 and 2024. What is different, and then
Madam Chair, Commissioner Tuma, sorry, you're talking about the year 2023?
No,
you're talking about the decision options.
Your
I
new
apologize.
decision option.
Yeah.
The one you filed.
I'm dyslexic, 4023 and 4024.
4025.
Thank you. So to be clear, we support 4025 for the next rate case. In this rate case, and I forget which decision option it is, but our CCOSSs allocate those costs the way Xcel has done, RO1. And so this recommendation in 4025 is not going to impact the current rate case.
It's teeing it up for next one. Xcel?
Commissioner Tuma, we don't support 4025. It's an even more significant cost shift than the OAG's initial recommendation. We don't think it's supported by cost causation.
That's all I got on class cost of service, Madam Chair.
Volume 5. Commissioner Partridge.
Thank you. Chair Sieben, I am going to propose, if it's okay with you, that we start with a discussion on the RAMP program, the Residential Arrears Management Program, and the late fees, which I think are connected, just because one of the parties that I want to talk to needs to get out of here soon. Mr. Shardlow, that's you. You want to come on up? And I will use that as my excuse to be really efficient with this conversation. So I'm just going to start with kind of what I'm thinking about these two things. So obviously, this is the Residential Arrears Management Program, as it is proposed, would be funded by late fees. And then we also have recommendations in the record around changes to late fees. So they're very closely connected. In your opening, Mr. Shardlow, you talked about how this was a particularly regressive funding mechanism for the arrears program. And I tend to agree with you. I won't belabor the issue, but, you know, I had been thinking about this, and I was listening to a piece on the radio about a recent Brookings Institute report on affordability, and they interviewed a woman who said, you know, she doesn't make enough money to pay all of her bills at once, and so she said that she jokes that her bills take turns being late. And so that really resonated to me, and I think that a lot of people out there are doing that, where you are juggling which bill needs to be paid today in order to prioritize your needs. And so I would like to propose that you, Mr. Shardlow, and Xcel work together, and I'm going to throw out an idea to you, and if my fellow commissioners hate this idea, then you can let me know, obviously. But so I was interested in 5033 under the late payment and reconnection fees, which just says that it would reduce late payment fees to the utilities cost of debt, so you would not be carrying any costs on behalf of those customers, and waiving late payments for low-income customers. So that is one decision option that I was interested in, but I also am really interested in the RAMP program, which is a bit of a contradiction. So what I will throw out there is that I'm wondering if you all could work on, you'd still be getting some late fee revenue, so you could still use whatever revenue comes in through late fees to fund the RAMP program. But for the commission to consider, I'm wondering if you guys could think of a mechanism to fund the RAMP program fully at the estimated amount, which is about $6 million a year. So any delta between what revenues you pull in for late fees and the amount of that annual budget, if you could put your heads together and propose a funding mechanism that could be recovered in a future rate case. My thinking, Chair Sieben, is that way it wouldn't affect the revenue requirements in this case, so we wouldn't need to worry about trying to get it into our final rates calculation for consideration next week, but it's something that they could think about and propose, because I do think it's a really valuable and important program. But I think CUB had some good description in the record, and Energy Sense did as well, that if we fund this program through late fees, we're basically taking it from low-income people and giving it back to them to pay down their arrears. So that is a proposal I wanted to throw out first while Mr. Shardlow is here, and get, Mr. Shardlow, get your reaction, and Xcel, your reaction as well.
Mr. Shardlow.
Thank you, Madam Chair, Commissioner Partridge. So just to make sure I'm understanding, so in this proposal, for all customers, it would be limited to the 0.45%.
Yes.
It would be waived for low income. We would come up with a new revenue number from the remaining that would be lower than 6 million.
Mm-hmm.
The delta would, yes, I would be happy to work with the company.
Okay, and before we move on, I do want to say one of the reasons I like this idea of waiving the late fees for low-income customers is not only would that reduce a financial burden, but also Cub had a really good point, which is that LIHEAP customers could not participate in RAMP, so they could be funding RAMP and not eligible to participate, and this would eliminate that. And then the other point I want to make is that I don't know that you can pull together an estimate of the total revenues with under 5033. So if you cannot do that, then think about a flexible mechanism for funding it that we can true up essentially. And Mr. Dobson, what do you think about this idea?
Thank you, Madam Chair, Commissioner Partridge. My understanding, and Mr. Martin can correct me if I'm wrong, but under 5033, I believe it kind of would sort of cut the funding to about a third of what we've proposed. So I think, we're talking about in 2026, $5.8 million, we get down to just probably under 2. Sorry, the mic, I'm doing my best. So if I just want to make sure I'm understanding your proposal. So the concept would be that we would do that. We've gone from 6 to 2 is under my numbers, and now we've got to make up that
6 million to 2 million?
Yep, 6 million to 2 million of funding for RAMP.
Mm-hmm.
So we've got to make up that 4 million somehow, but it sounds like from not in the revenue requirement, some other type of mechanism. Because obviously that's the simplest way, is you just, increase the revenue requirement, but that didn't sound like what you were thinking. We have to think of some different mechanism to do that. We can put our heads together. Obviously the things I'm thinking about are sort of, deferrals, assets, things that sort of hit the revenue requirement down the road. But we can think through if there's a way to sort of make that up. And certainly willing to work with ECC to try to figure that out.
Sorry, I'm not trying to be obstinate here, but I understand, I think what you're saying, Commissioner Partridge, where you reduce the late payment charge, because why are you charging late payment fees for people that can't afford it? Mm-hmm. But you still want to use that money like is proposed in the RAMP program to pay down arrears. Mm-hmm. But because we're reducing the overall amount collected, you're asking the parties to come up with a way to make up the rest of the money?
Yeah.
Before next week?
Yeah.
That's what I'm not like, or maybe a proposal is like in the next rate case or in another gap or another like affordability docket. I don't know. I'm just not sure. Like, I support the outcome of what you're saying. I just don't know how we give the parties time to do that before we make a decision on the final, you know what I mean? Like, I wonder if we could do it, but then kick off make the final determination of how to come up with that additional revenue in a different docket. Perhaps, I don't know. Or what, or do you think there's another like revenue source in this record that we're gonna come up with next week or soon, Mr. Shardlow? You know, like it sounds like a good idea. I just don't know how we're gonna, again, it's kind of like, I don't know what we're doing, how it will work.
It reminds me of end of the legislative session. You got 2 days to get it figured out, or we're moving on.
Or we could just reduce do 5033 and 5034 and then ask the company to work with stakeholders to come up with a funding mechanism in another proceeding. I don't know. Mr. Edstrom, I mean, that's not your name, sorry. Do you have
Madam
any?
Chair, Commissioners, Brandon Crawford with the
Crawford.
Citizens Utility Board of Minnesota. First, to address the last statement you made, I think 5033 and 5034 are opposites of each other. So we'd want to move forward with 5033, as Commissioner Partridge was speaking to. One of the alternatives that Witness Levinson Falk had proposed in the record is to utilize the revenues under that lower late payment fee amount and using that to offset any surcharge increase to power on that would result from automatic enrollment. So that might be one thing that you could do in the interim while, working through these issues to try and identify a pathway forward to have ramp at that higher level. Or you have it at the lower level of the late fees until such time as you can identify a method to increase it towards the original 6 million-ish.
Mr. Shardlow, I think you.
So, Madam Chair, Commissioner Partridge, if I could clarify a few things / think out loud. So, to be clear, power on is to serve people 50% SMI and below.
Right.
Ramp would extend arrearage.
80.
Power on is for 50% and below and has its own arrearage forgiveness components within that program. This ramp would be a service to those at 80% SMI or below. So I do, just as we're thinking through equivalence, I do want to be clear about that. I'm happy to confer with
If
parties,
Xcel wants to pay for it with shareholder money, for example, and propose that by next week, that would be like a healthy solution here, Mr. Dobson.
Madam Chair, can I just
in
say
the interest of moving this forward, but I think that might not happen. But Commissioner Partridge, I think like this is helpful discussion and it can give the parties chances to reflect on, like, I support where you're headed with 5033 and 5034, right?
No, just 5033 and then 5015.
And then what do you want the parties to?
How about this?
Come up with an idea.
Yeah, how about this? This will be my proposal. How about Mr. Dobson file a decision option with us, and because this wouldn't necessarily affect the numbers for this rate case, if it doesn't affect the numbers, you don't have to file it by Monday or whatever. But file a decision option that gives us a path forward. And that could be you make a compliance filing or you work with parties to make a proposal in another docket. But I think you understand what I'm trying to say, which is I think this is a valuable program. I want to find a way to fund it. And yet I do want to, I'm in favor of reducing late fees.
Madam Chair, Commissioner Partridge, we can certainly file a decision option that gives us a path forward. I will just throw out there, although I'm positive you've thought about this, but in light of the numbers, may possibly a step to consider. With 5034, we don't have the numbers of what that would do, but I know it would reduce funding significantly less. We sort of target the waiver to low income customers. We don't reduce the late fee for people. If I'm late on my bill, I haven't lose it or anybody else. That maybe there's something there to consider, but we'll be happy to file something else.
Okay. I favor 5033. I understand that trade-off. So if you could work with CUB and Energy Sense to just let us know, as Chair Sieben is saying, where should we figure this out? And I do want to do it in a timely manner.
And Commissioner Partridge, sorry, I'm just trying to understand if they're collecting lower fees it will help. You could still approve the program. They just won't have as much money to go towards paying down the past bills that are due,
Right.
So
I do want to make it really narrow. Whatever discussion you have is really just, is there an appropriate way to fund this at the estimated level, the originally estimated level? But we would approve the program here, and you could start with the revenues that you receive through late fees and go ahead and get that going, and then make wherever you think that discussion would best be had of how you might make up that delta, which is about $4 million a year. And that way we don't rehash. I don't want to rehash the program. I don't want to talk about program design. We are going to go forward, but just narrowly figure out, is there an appropriate way to fund that $4 million? And I guess, CUB, do you support that? I think.
Madam Chair, Commissioner Partridge, yes.
Okay, because I know initially you didn't support RAMP, but I think it was just because of this funding mechanism. Okay.
you're finding a way to ramp it up.
Yeah, ramp up the ramp. Okay. All right, now, Mr. Shardlow, you can go pick up your daughter from daycare. If you're paying for every 5 minutes you're late, I apologize.
We all apologize. It's not just you.
Okay, I have a few more questions, and they're in other areas. I have one for the department. I just wanted to clarify with you that the department supports 5001, is that correct? Which is Xcel's proposed revenue apportionment. You're not listed, but I thought you did for some reason.
Chair Sieben, Commissioner Partridge, the department supports decision option 5002.
Oh.
And what's the difference,
Okay.
sorry, to the
Yeah.
follow-up, Commissioner, on Commissioner Partridge's?
The second year, right? So, Chair Sieben, and I'll let you clarify, but I think the reason I thought you supported 5001 is the only difference that you want to use the 1 year, and the company is proposing 2 separate years, so 2 separate numbers.
Chair Sieben, Commissioner Partridge, yes, that's the main reason.
Okay. Okay. Do you feel strongly opposed to 5001?
Commissioner Partridge, Chair Stephen, Commissioner Partridge, I would have to double check with
Okay.
Nancy.
Okay.
Do that.
Yeah, ask her on a scale of 1 to 10. How committed? Okay, let me flip around here. Okay, so then, did not have a question on that. Okay, the only other, there was great record development on this. I am very interested in some of these proposals and excited about the changes to the LUAC. But I don't have questions because you guys did such a great job of record development. I guess the only one that I'm kind of unclear on is street lighting. I think if SRA wants to come forward. Can you, in a very brief and efficient nutshell, explain to me what you're concerned about and what actual dollar impact you think this will have?
Commissioner Sieben, Commissioners, on which?
On the street lighting, I think that you were concerned about overhead fixtures and the change in cost for those.
Yes, absolutely. Succinctly, the impact to the overhead fixtures when weighed equally is disproportionate, as reflected in the table that Mr. Bride presented. It is not just a percentage increase, it is an actual dollar increase. And I would have to refer to
Okay.
yes.
On page 27.
You are faster than I am.
Table 5. Okay. So I see the dollar impact. These don't look that big to me. And so I guess that's what I'm trying to understand is kind of like I said to the department, is this a level 10 issue or is this like, it's not great, but it's not going to break anybody's municipal budget?
It is not, while we stand by our recommendation, I will say it's not going to break any municipal budgets.
Okay. And then I think in your opening, you said that it's going to more heavily impact certain communities. Can you remind me again what you said?
Absolutely. Communities with a higher percentage of overhead fixtures are generally those closer to the urban cores, which are older.
Okay.
With newer developments, the underground lighting feeders were installed more frequently.
Okay, that is helpful information. Those are my only questions. If others have questions, I'm mostly done, I think. We're all done.
No? Okay.
Sucks to be last, right?
Any other housekeeping issues from staff or parties that to take care of? Okay, well then, thank you everyone for a productive day. The meeting is adjourned and we'll see you back next Thursday at 10 a.m.